Chief Justice and the Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sitting en banc is now in session.
Good morning. Welcome to oral argument. The clerk may call the calendar.
Good morning. Supreme Court of California sitting in San Francisco on Thursday morning, May 5th, 2016 at 9 a.m. Case number S213468, City of Paris, Plaintiff and Respondent versus Richard C. Stamper et al., Defendants and Appellants. Continued to the late May oral argument calendar. Case number S232642, Edmund G. Brown, Jr., as Governor, etc. et al. Petitioners versus Superior Court of Sacramento County Respondent, California District Attorneys Association et al. Real parties and interests. For petitioners Edmund G. Brown, Jr. as Governor, etc. et al. James C. Harrison.
Ready.
For real party and interest, Kamala D. Harris as Attorney General, etc. Paul Stein. For real parties in interest, California District Attorneys Association et al., Thomas W. Hilltack. Case number S225090, Robert C. Barrell, Plaintiff and Respondent versus David Schnitt, Defendant and Appellant, for Appellant James M. Wagstaff. For Respondent Gerald L. Sawyer. Case number S224929, The People, Plaintiff and Respondent versus Zeferino Espinosa, Jr., Defendant and Appellant. For Respondent, Bruce Ortega. For Appellant, Lawrence Gibbs. Thank you, Counsel.
You may proceed on the Brown versus Superior Court matter.
Good morning, Chief Justice and Associate Justices. James Harrison on behalf of petitioners Governor Jerry Brown, Margaret Prinzing, and Harry Barroson. This case presents a very narrow question: whether the Attorney General properly exercised her discretion in determining that an amendment to a ballot measure was reasonably germane to the theme, purpose, or subject of the original measure pursuant to Elections Code Section 9002.
Counsel, what does reasonably germane mean to you?
Reasonably germane to me, Your Honor, means that the Attorney General is directed to apply the standards set forth in this Court's single subject jurisprudence. And the reason for that is twofold. First, in setting the standard, the legislature drew verbatim, word for word, from this Court's decision in McPherson versus Open Primary. The legislature, of course, is deemed to be aware of this Court's jurisprudence, and in using a term of art like reasonably germane to the theme, purpose, and subject, it intended that that same jurisprudence be expounded in the same sense in the statute.
Does our jurisprudence speak in terms of reasonably germane in the single subject area to the theme, purpose, or subject? Do we use that phrase in our cases related to the single subject rule? You
do indeed, Your Honor. It's used multiple times. That particular phrase is used word for word in the McPherson decision, but the same standard is set forth in this Court's decision in Senate versus Jones. So it is a standard that is commonly employed by this Court to describe the single subject rule.
Is it an accommodating and lenient review, or is it something more narrow when it applies to initiatives?
It is an accommodating review. In fact, in Senate versus Jones, this Court specified that the single subject rule is to be given a liberal construction. And that, of course, derives from the fact that this Court, like all courts, resolves all doubts in favor of the people's exercise of the right of initiative.
Let me pick up on that. By the time we're addressing the single subject rule, the initiative has been passed by the vote of the people. And as you reference, we are deferential to the people's expression of their will. This statute is completely different, and one could argue that it has a completely different purpose, that its purpose is to inform the people as to what they will be voting on. And if there's a radical substitution of subject after the people are given the opportunity to comment, it would be a different interpretation of reasonably germane.
Well, I certainly agree with Your Honor that the purpose is different. The Attorney General is not reviewing the amendment to determine whether the measure as a whole can be presented to the voters under the single subject rule. Instead, she's tasked with identifying the chief points and purposes of the measure and determining whether the amendments are reasonably germane to the theme, purpose, or subject of the original measure. With respect to the public's right to comment, the legislature accommodated that by setting forth a 30-day public comment period. And then it specified that proponents could submit amendments after the close of that 30-day.
If I might interrupt you, what's the purpose of the comment period if after that, as here, the proposed initiative is changed? The comment period becomes irrelevant and an exercise in futility.
Well, I would disagree with that, Your Honor, because the comment period can, in fact, inform the amendments themselves. In fact, in this particular case, as is set forth in the record, the proponents engaged in widespread outreach to obtain input regarding the measure, not just the input they received through
what is the purpose of Section 9002? The amendment process.
The purpose of Section 9002 is to give proponents a tool through the submission of public comments to improve their measure. And this may mean that they negotiate with other proponents who are considering a competing initiative to join forces. It may mean
because of the process that we're now in, is that process foreclosed?
Well, Your Honor, if the legislature had...
Well, first, the answer to my question. Is there still an amendment process?
Yes, there's an amendment process. And what
is there a public comment process?
There is a public comment process, but not after the amendments are filed. But let me just address that point for a second.
It's an amendment.
Correct.
That was filed.
Correct.
So there's no public comment.
I would disagree with that.
Okay.
For two reasons. One, the legislature only provided one public comment period during the initial 30-day period.
That's now gone.
And that's now gone. The legislature simultaneously said proponents can file amendments after the public comment period closes. However, that is
reasonably germane to the original process.
Correct.
Now, don't we have a slight problem here in that the amendment was slightly different than the original juvenile justice program that was advanced?
The amendment was different by definition. It was an amendment. But, Your Honor, the amendments...
Was it a sweeping change?
Well, in fact, Your Honor, the initial measure made sweeping changes. Let me just make one point of comparison. Both versions contain provisions relating to parole. The original measure would have authorized parole eligibility for state inmates who committed their crime before the age of 23, whether a violent crime or nonviolent crime, irrespective of consecutive sentences, enhancements, or three-strike sentences.
So the fact that they both talk about parole makes them reasonably germane?
No. What makes them reasonably germane is that all of the provisions of both the original version and the amended version relate to the single subject or theme that's explicitly set forth in the title and the findings of both measure, which is rehabilitation in the criminal justice system for the purposes of advancing the goal of public safety.
Counsel, but would you at least acknowledge, perhaps, or if not, tell me why you wouldn't, that a fair-minded observer reading the original measure would say that it's primarily about juvenile justice, and a fair-minded observer reading the revised measure would say it's not primarily about juvenile justice?
I would say, Your Honor, that there was an emphasis on juveniles in the original measure, but that emphasis carries through to the amended measure as well because it contains the same core provisions.
The original measure said that its goal was to ensure California's juvenile and criminal justice systems stop recidivism and so on and so forth. Right?
That's correct, Your Honor.
Even the original provision seemed to take into account, because we don't ordinarily call the juvenile justice system a criminal justice system.
That's absolutely correct, Your Honor. There can be no doubt that the original version addressed both the juvenile justice system and the adult criminal justice system.
Does it make a difference, however, that the original version spoke to amendments to our statutes? However, the revised proposal now has a constitutional amendment which carries with it greater ramifications in terms of future change?
I don't think it does, Your Honor. Ballot measures frequently incorporate both constitutional changes as well as statutory changes, and whether the measure includes one or the other or both is not relevant under this Court's single subject jurisprudence, Brosnahan versus Brown. The question is whether the provisions themselves in the amendment are reasonably germane to the subject, theme, or purpose of rehabilitation in the criminal justice system.
So at
which
what level of
they
generality, then, is that analysis appropriate? So you can imagine that the argument could be made that these are both about the legal system. That would not be sufficient, presumably. So apply the test and tell us at what level of generality the analysis occurs.
Your Honor, this is actually a quite narrow subject matter compared to other measures that this Court has upheld against single subject challenges. Think of Brosnahan versus Brown, for example, the Victims' Bill of Rights, which covered everything from bail to restitution to safe schools. Similarly, Raven versus Duke-Majan, another criminal justice reform measure, had a sweeping effect, including a provision that restricted this Court's role in construing statutes. So this Court has upheld far broader reform efforts than the one at issue here.
I would like to go back to the Chief Justice's point. The originally submitted statutory amendment related to legislative opportunity to change parole, am I correct? But what I want to get to is the constitutional amendment. That's a structural change, if you will, when you have matters that the legislature can later amend if they wish. But once you have something in the Constitution, it's completely different. I would propose that that could be viewed as a structural change.
Well, Your Honor, I understand the significance of amending the Constitution, but the truth is that ballot measures in California frequently amend the Constitution and add statutory provisions. And of course,
well, I understand that, but we're talking about what was originally put out for public comment, and what the public never saw was that it was proposed that the Constitution of the state was going to be amended.
Could I just address one point you made, because I think there's a misconception about the public comment period and the purpose it serves. First of all, the public comment period was not intended to create a public forum. In fact, the legislature expressly prohibited the Attorney General from posting those comments on her website. They're provided only to the proponents. So the public comment period, in fact, serves the purpose of providing information to the proponents of a ballot measure. They're free to disregard it. They're not even required to read it.
If I could take you back even one more step.
Sure.
We never had a public comment period in this state until this statute, right?
That's correct.
And I don't think anyone would dispute that the legislature can set up a public comment period if it chooses and can define what that period looks like. So the nature of the exercise here is simply to try to discern what the legislature intended by way of public comment. You are suggesting, legitimately so based on the structure of the law, that this was not a forum for open debate. And it seems pretty clear to me that the legislature wanted to give a great deal of latitude to the proponents of any initiative, just as they have had since the initiative process was enacted. So does that, is that consistent with the argument you're making?
Absolutely, Your Honor. I mean, in fact, if you look at the structure of the law prior to the changes set forth in SB 1253, a proponent was restricted to making only technical, non-substantive amendments during the first 15 days after the measure was submitted. If the proponents submitted substantive amendments, it would restart the clock during that 15-day period. If they were submitted after that, the proponent would have to start over. So one of the legislative purposes here was to provide tools to the proponents to address questions, comments, concerns that were raised in connection with a ballot measure.
The overall design of the statute is to leave the proponents in the driver's seat.
Absolutely. And let me just make one other point. This public comment period, these 30 days, is not the end of the road. This is not a situation like what Mr. Hiltak refers to as the despised gut and amend, where typically the public doesn't even have an opportunity to see a bill, let alone provide input, before it's adopted by the legislature. Here, following the public comment period, the proponents filed amendments. The amendments were posted on the Attorney General's website for a period of 30 days before the title and summary was issued. The public had the opportunity to comment directly with the proponents, as two of them in fact did, and had the proponents believed that those comments warranted some change, they could have withdrawn the measure, they could have submitted a new measure, and that's not the end of it.
The real public forum for this kind of thing is the signature gathering process, and then ultimately the vote.
Precisely. This is just the starting point. That 30-day window is just the starting point. What ensues from that are multiple opportunities for the public to provide input. They can challenge qualification. They can refrain from signing a petition. If the measure qualifies, they can campaign against it. And on Election Day, if they don't like it, they can vote against it, which is the ultimate public comment.
Factual question. Can you remind me again the date on which this amendment was filed?
The amendment was filed on January 26th.
Okay. Then did the legislative analyst and Department of Finance meet the 50-day deadline for?
The legislative analyst submitted the analysis one day late, and the Attorney General, after this court issued a stay, timely issued her title and summary.
Yeah.
And I'd like to point out one other thing, by the way. The legislature considered whether or not the legislative analyst should be given additional time after an amendment was filed. In fact, the Assembly Committee report raises concerns about that. But the legislature nonetheless decided that they would not increase the amount of time that the legislature had.
I'm just curious if you have any knowledge of how that went. I mean, that's a very short period of time, 15, 16 days, to analyze a very big change.
It is. However, the legislative analyst began the process, of course, when the measure was filed. And again, it had provisions that were very similar to those set forth in the amendment. Furthermore, the legislature gave the legislative analyst an out. If the legislative analyst determines that those 50 days are insufficient for the legislative analyst to render a conclusion, then the legislative analyst doesn't have to.
As a follow-up to Justice Liu's question, was it a big change?
I'm sorry, what, Your Honor?
Big change?
I'm not sure I understand.
Information?
Was what a big change?
Was the amendment and the analysis of the fiscal consequences a big change from the original analysis?
The fiscal impact, did it show
a big change? What was the difference?
We wouldn't know, Your Honor. We'd only be speculating because legislative analysts didn't produce an analysis for the original measure.
But let's go. I would like to go back to the issues raised by the Chief Justice and Justice Wardiger regarding the constitutional amendment. The original language was an amendment to a statute, correct?
Correct.
And now we're dealing with a constitutional amendment.
That's correct.
That seems to be a major difference, and to eliminate the public comment period when you're suggesting a constitutional amendment seems to me to be wrong.
Your Honor, it is a difference. Obviously, it's a constitutional amendment versus a statutory amendment.
When you propose a constitutional amendment, it seems to me you would want the public to comment on, to put in their 2 bits worth on whether or not it should go forward.
Your Honor,
Harrison, you may answer the question, but I presume you'd like to spend some of your time for rebuttal.
I would. Thank you, Your Honor. Let me briefly respond. The constitutional amendment relates to the same subject as one of the statutory changes in the measure, which, as I said earlier, would have made sweeping changes to our parole system. The proponents, in response to the original measure in that parole provision, received 0 public comments, Your Honor. So I would offer that as evidence of the level of interest in the public at that phase. Thank you.
You'll have 3 minutes on rebuttal.
Good morning, and may it please the Court. The Attorney General has an institutional interest at stake in this case that's distinct from the interest of the petitioners in clearing this ballot measure for signature gathering. Our concern here is that the trial court created an unworkable standard for deciding whether an amendment is acceptable under the statute going forward. We have to administer this statute routinely. We've already done so in roughly 40 cases since the law took effect in January of 2015. The trial court's ruling, if left uncorrected, would heavily discourage proponents from submitting amendments to ballot measures, which is the opposite of what the legislature was trying to achieve. The overriding goal here in providing this ability to amend was to remove pre-existing restrictions in the law that made it difficult or impossible for ballot measure proponents to make changes when they wish to do that.
So if the trial court applied an unworkable standard, what is the right standard?
Well, I think we have to go back to the plain language. And your first question is, what does reasonably germane mean? And I think if you look at that language in isolation, even putting aside all of the single subject case law and the statute's derivation from the single subject case law, reasonably germane, I think it's fair to say, means reasonably related. And the statute also allows, which I should say is a fairly elastic and generous standard.
It is, but if it's not a standard that commits essentially to the Attorney General's discretion, the decision, give us an example of what would be the outer limits of that standard.
Well, I think of a phrase used in the Brosnahan case where under the single subject rule, if a single measure proposes a grab bag of social, political, economic reforms.
Grab bag is a more workable standard?
Well, no, it would be easier to identify a grab bag as one that might not, as a measure that, or an amendment that might not be reasonably germane. So, for example, if this measure started out as promoting rehabilitation in the juvenile and criminal justice systems, and then was amended in late January to include a bond to fix the state's streets and bridges, I think the Attorney General could safely say the amendment was not reasonably germane.
So you don't think it's a problem that it starts out as an amendment to the juvenile statutes and ends up as a constitutional amendment?
We don't, Your Honor, because germaneness is a function of relation, how related the amendment is to the original in terms of subject matter, more precisely in terms of the theme, purpose, or subject.
What is the subject matter?
Well, as Mr. Harrison indicated, we determined that it was promoting rehabilitation in the juvenile and adult criminal justice systems with the goal of enhancing public safety.
You know, it's hard to imagine an amendment to a proposal that would not be, in terms of lawyers' argument, would not be reasonably germane to theme, purpose, or subject. I mean, that's pretty broad, and it depends on how atmospheric we want to get in describing what the original proposal was. But I have a more practical question, and I know this was alluded to in the briefing, and that was if, for example, this trial court order stood and, in fact, determined that these amendments were not proper. My understanding is then that the proponents of this initiative would just have to start over, which would mean they'd lose their place in the line to qualify for title, ballot, and summary, correct? I mean, they would lose their place. They would have to start over. That would take time and money. So what really this means is it would be a delay in furthering, in getting this amended proposal a ballot title in summary as if it were new. Would that be a serious ramification for this?
Well, that would be the practical effect of the ruling.
Starting over, have to start over.
The Attorney General was required by the writ issued by the trial court to reject the amendment and to treat the amended version of the measure as a new measure, in which case the proponents would have to go back to the beginning of the process, pay another filing fee, wait for public comment for another 30 days, and then move forward from there. So yes, that would be the practical effect. But in our view, that would be contrary to what the legislature was trying to do here. I mean, the legislature was trying to make it easier for ballot measure proponents to make changes, to improve their measures, to give them time to reach compromises with other stakeholders in the field, to avoid cluttering the ballot with overlapping and competing measures. We also have to go back to what this court has said about giving a liberal interpretation to statutes governing the ballot measure qualification process so that we don't unduly restrict the people's right of initiative.
Can I ask you a question about our relative roles in the process? The initial judgment as to whether or not the amendment is reasonably germane to the original is made by the Attorney General under the statute?
That's correct.
It's made within the scope of her sound discretion?
That's correct.
So would you agree that when a court reviews that judgment, it applies the traditional abuse of discretion standard?
Well, we believe that the Attorney General is entitled to deference in determining what the theme...
The general standard would give a fair amount of deference, would it not?
Correct.
In other words, we would only overturn, a court would only overturn that judgment if it's beyond the realm of reason.
That's correct. And
Is that a different standard than when we review an enacted initiative for whether it satisfies the single subject rule? Based on what Justice Carton said, do we have a lesser role here if we're deferring to the earlier judgment of the Attorney General?
Well, first of all, the Attorney General is not determining whether or not a ballot measure complies with the single subject rule.
He determines this is reasonably germane. Is our role in reviewing that different than when we're looking at an initiative that's been passed and we're trying to determine if it satisfies the single subject rule?
Well, I think in this case, the Attorney General is entitled to some deference because...
So is the answer yes?
I believe the answer is yes.
But are you making a case that deference is owed separate and apart from the abuse of discretion standard, or are you just acknowledging that the abuse of discretion standard applies?
It applies, and it's guided. The application of that standard is guided by the fact that the Attorney General, is entitled to some deference in deciding what the theme, purpose, or subject of the original measure is, because that's the starting point of the analysis. We start with determining the theme, purpose, or subject, and then standing alone, and then look at the amendment to decide whether it's reasonably germane to that.
And if we ultimately are challenged to determine whether or not an initiative satisfies the single subject rule, we're doing a different kind of comparison, are we not? That when the Attorney General makes her threshold determination, she's comparing an amended version of something to the original. When we are engaged in that process, we are comparing the initiative, the parts of the initiative internally, right?
Correct. And you're making that determination in a very different context. At the single subject stage, you're deciding whether or not the measure was potentially deceptive or misleading to the voters. Your job there is to protect the integrity of the election and voter preference. But at this stage of the process, we're nowhere near the election. The voters haven't even seen the measure yet. This is simply a matter of qualifying the measure and clearing it for signature gathering. There's no risk of public harm here. I can see my time is short, so with that, I would just urge the court to grant the relief requested in the petition. Thank you.
Good morning, and may it please the court. SB 1253 was intended to improve the initiative process, and we believe petitioners' interpretation of the statute actually does more harm to the process than existed prior to SB 1253 being enacted.
Well, before it was enacted, there was no comment period, right?
There was no comment
We
period, but
staggered
there was
along with
also
no comment period for a century here in California.
There was no comment period, but there was also practically no opportunity to amend an initiative to correct errors that were discovered during the early processes of qualification. And that was the objective of, one of the primary objectives of SB 1253, was to provide a process where an amendment could be made to fix an unintended consequences, to fix a typo, to fix a misstatement of law.
So you're suggesting the amendments were not intended to change the scope or the subject matter?
Absolutely not. They were limited by two things. One is the word amendment.
But isn't reasonably germane dramatically broader than fixing typos?
Yes, I think it is.
Unintended consequences?
Yes, I agree that it is, Your Honor. And they could have certainly said you could fix typos in the first 35 days. But reasonably germane is still a limitation. So you have a limitation use of the word amendment. Amendment is defined in Black's to be essentially to fix errors, to improve. And that's not what occurred here.
Can I ask if your argument is weakened, however, because that limitation was placed in the uncodified text of the bill versus in the actual text of the statute?
No, I think it's an expression of legislative intent in the bill. That was the objective of SB 1253. And if you look at those terms, to fix, to repair, to improve, to address unintended consequences, those are all...
Are those the only terms that are germane to an amendment?
No, but those are all terms...
Amendment is a fairly commonly understood to be a fairly broad kind of action. Certainly some of them are minor fixes, but there's nothing in the legislation that indicates a legislative intent to impose that kind of limitation.
No, I think the use of the word amendment actually does, Your Honor. Black's defines amendment to mean to improve, to change for the better by removing defects or faults, to change, correct, revise.
Well, to change, let's stop there. That's the one that is difficult.
Right, and that's where the word reasonably, that's when the reasonably germane standard comes into place.
Do you differ with your opposing counsel that this is reasonably germane? It deals with juveniles and it deals with prison sentences. I mean, the way we've interpreted the single subject rule, that would certainly come under the umbrella.
I do. It is not reasonably germane. And let me explain why. Petitioner's counsel described the second submission as follows, quote, "It's an important statewide ballot measure with far-reaching effects on our criminal justice system and the ability of the state to respond to a federal court mandate to reduce its prison population," close quote. That is most assuredly an accurate description of the subsequent amendment. It is not a description of the original filing. The original filing addressed 11 statutes, mostly in the Welfare and Institutions Code, and all directly related to juvenile justice.
But presumably the reasonably germane language does not force one description to converge precisely with the other. So in other words, if there is a problem, what is the most severe problem that you see? What is the precise reason why you think this does not get covered by the reasonably germane language?
Two comments on that. First is that the reasonably germane standard is applicable and established, the framework is established by the original filing. And so the use of the single subject words or the vernacular or analysis is a little misplaced in my view, because as Justice Corrigan just described, the single subject rule is intended to look at sort of the basket of laws that are proposed to be changed and decide whether that basket of laws fits within a single subject and is not excessively broad.
You say that concept or language is misplaced, but the problem is that's what the legislature chose.
Right, but they also modified it to refer to the originally filed initiative.
Well, they
and the
had
originally
to refer to
filed
something.
Initiative was clearly a juvenile justice reform measure, which is what the trial court found. It amended 11 statutes. All of them applied to juveniles.
Let me ask you, in the bill drafting history, we learn a few things. Originally, there was a version of this bill that provided for amendments without limitation. And at the time, it was said that public comment could address drafting errors. But then in a later bill analysis, it was then observed that there are no limits to amendments that could be proposed, and so there was, in the language of the analysis, the possibility of spot initiatives. Right? So the worry is that someone will essentially file a spot, take a spot, and then dump essentially a substantially different text into that vehicle, right? And that would constrict the number of days that the legislative analyst would have to do its fiscal impact analysis, and also would limit public comment on that. Now, having considered all that, the drafters then drafted what they drafted, which is they chose two provisions. One, the reasonably germane standard for amendments, and secondly, the idea that there can't be any amendments if the original submission affected no change in substantive law, meaning that was not even a true initiative in a sense. But that's it. So those are the outer boundaries. On the one hand, you cannot just literally put on a spot initiative, meaning no substantive proposal. That you can't amend something. You can't amend zero, right? 0 times amendment is still 0. And then on the other hand, at the outer edge, if you have something substantive, it's whatever's reasonably germane. That's the accommodation that the legislature chose in response to the very concerns that you have raised in your briefing. It's not that the legislature didn't think of all the things that you've said. They did think about it, and this is what they came up with.
I agree, Your Honor, and I think that the reasonably germane standard addresses the same concern as the spot initiative standard,
that
which
would
is
be a very
you cannot
odd, given the history of how that term has been construed in our case law, and you don't disagree that that is a term of art borrowed from our case law. It's hard to. It's hard to escape the conclusion you're urging us to adopt a statutory interpretation of those words different from the constitutional interpretation of those words. The single subject jurisprudence.
I don't think you have to do that to reach the same conclusion that was reached in the trial court here. What you have to do is, if we're going to move to that step, is to say, okay, well, what is the subject matter of the first submission?
You think that the new amendment here, as compared to the original, is less related than the types of wide-ranging measures that we have approved in the Brosnahan case and the other cases in our jurisprudence?
I think Mandalay is a perfect example. In the Mandalay case, this court was faced with determining whether Proposition 21, a juvenile justice reform initiative, was a single subject. And there was changes to the three strikes law, where there was a lock-in provision about listing serious and violent felonies, that initiative made changes to. And this court held that the single subject of Proposition 21 was juvenile justice reform and gang-related crime. It didn't take the easy way out and say, well, this is just criminal justice. Of course, criminal justice is a single subject. In fact, this court struggled with the fact that there were some of those provisions that related and affected people beyond juveniles.
But how do we know the right level of generality? Why should we identify the level of generality that you are prescribing as the correct one?
I think for a couple of reasons. One is this is a procedural process, which we are attempting to provide a vehicle for initiative proponents to improve their initiatives, not change them. And this is clearly a change. We've talked about the fact that this was a constitutional amendment. It's not just the fact that this is a constitutional amendment. This constitutional amendment provides a constitutional right to parole, unheard of in our jurisprudence.
It may or may not be a good idea, but that's really
But it's
not
certainly
the question.
far-reaching, and it certainly was not contemplated by the original filing.
Right.
There was no constitutional right to parole in the original filing. There was no discussion of prison credits. There certainly was no discussion of prison credits being awarded by the Department of Corrections.
What is your concern? Let's go back to the purpose of this legislation. Is your concern that the public who had the opportunity to comment in the first 30 days has been hoodwinked? What was the purpose of allowing public comment, and what is your concern with relation to that purpose?
My concern is one, in one respect, the public comment period, and in the second respect, the period of time given to the legislative analyst and the attorney general to do the work that they do.
Can you go back to why you think this is, why you think there's strength in your argument by saying the public comment portion? What do you think the public comment was for?
The public comment period was an opportunity for people interested in the measure to read it, to make a determination as to what they thought about it, and if they thought that they found an error or that there was something that maybe the proponent hadn't thought of, they could reach out to the proponent.
Well, but in this case, am I correct that there was no actual public comment, but there was consultation that wasn't on the Attorney General's website that led the proponents to refashion their initiative?
You could speculate that there wasn't much public comment with respect to the first initiative because the first initiative didn't do very much.
But we don't
it didn't
usually
apply to very
speculate.
many people.
So let's take speculation off the table.
No, but I think it's
I do have two questions I'd really like to ask you.
Sure.
The first one is the level of review. The statutory framework reposes the initial determination in the Attorney General, and the courts review that for abuse of discretion?
Yes.
Would you agree that when we apply an abuse of discretion standard in this context, we use the customary understanding of what it means to review for abuse of discretion?
Yes.
All right. Secondly, with regard to your spot initiative argument, I want you to have a chance to respond to this. It seems to me that in a spot initiative circumstance, a bill is proposed, it goes into the hopper, things happen, people talk about it, there's an opportunity for amendment, and then very late in the day, often a hugely transformative change from public safety to traffic can be made. It seems to me that this circumstance is different in the sense that the ultimate initiative, if it qualifies for the ballot, on which the public is going to vote, is set. No one's going to come along later after the whole political process has run its course and say, oh, we know you passed A, but horse on you, we're really going to enact X. It seems to me that the spot initiative, spot bill, spot initiative analogy really is inapt. So if I'm missing something, I need you to help me.
No, I think you're right, and I actually believe that the language relative to spot initiatives was actually unnecessary. A spot bill, this is the legislature thinking about its own processes, and a spot bill in the legislative context is usually a bill, a number, and a sentence that says relating to education. That's a spot bill. If you were to try to submit that to the Attorney General's office, that's not legislation. That's not something that the Attorney General would probably issue a title and summary for anyway. So that analogy, I think, is somewhat different. What I think the legislature was more concerned about was what occurred in this case. An initiative was filed that did change substantive law. It changed it in respect to a specific subject matter area, and that was then switched, bait and switched, gut and amend, hide the P, whatever you want to call it. But that initiative rendered a result that was completely different, or proposes a result that's completely different than the original filing.
Well, that goes back to the question of what was the purpose of allowing this public comment, and what is your concern that there was some major changes? The concern that the public didn't get to comment, or I think you referenced concern that it delayed the time for the legislative analysts to analyze the initiative.
Yeah, let's start with the public comment period. So, for example, in this case, had there been public comment period available, perhaps the proponents would have been told, you know, you used the term nonviolent. That term is not used in our body of criminal justice law.
Define it.
It's not defined. When you use that term, do you mean all felonies that aren't on the violent felony list?
Been improved.
It could have been improved if there had been an opportunity to alert the proponents to that issue.
But
they might have rejected it. They might have rejected it, but that opportunity was lost here. The legislative analyst's office might have said to the proponents.
I'll interrupt you though on this argument. Isn't it true that the legislature was aware that an amendment could be passed, could be proposed, that the public would not have opportunity to comment? I mean, that was in Governor Davis's veto of an earlier version of this kind of purpose. And the legislature knew, and they chose to ignore that and continue to pursue the language they have here. How does that factor into the legislature knew? They had to know. Everyone reads the governor's veto messages. They saw it. The legislature saw that. They knew that they weren't providing for a comment period to a subsequent amendment. They thought about it and they said, doesn't matter, because amendments or proposals are basically for the proponent's benefit.
I think you could also argue that it doesn't matter because the amendment will be reasonably germane to the original filing. And so when you provide a 30-day public comment period, it's possible that the comment comes in on the 30th day. And so the statute provides 5 more days for the proponent to deal with that and says, okay, well, if your amendment is reasonably germane to the original filing, no need for further public comment.
Am I correct that your opposing counsel said, I may have misunderstood, that there was some opportunity for public comment after the amendment?
There was no opportunity for public comment here. Now,
the process has to stop somewhere.
Correct.
So at the end of the day, there is going to be a version on which there is no public comment,
right,
except the public comment that occurs through the signature gathering process, the campaign process, and through the ultimate decision of the voters.
So let me give you an example applicable in this case. In the record, they've suggested that during their own review process, not through the public comment process, they decided that their amendments to Penal Code Section 3051, which would have allowed for parole consideration irrespective of a 3-strike charge, serious or violent felony, might be too broad. And they said, boy, we've heard that from prosecutors and others that maybe that's too broad. Had they filed an amendment in the 5-day window that said 3051 should not, that parole right should not apply to violent felonies, that would improve, it would address an unintended consequence, and would have been reasonably germane to the original filing.
You've mentioned several times, counsel, that a constitutional amendment is at issue in the revised initiative. How central is that to your argument? Would this be quite a closer case if it were not a constitutional amendment?
I think it would be a closer case if it was not a constitutional amendment. I think because it's a constitutional amendment, it has such far-reaching impact. Had they, much like in the Mandalay case, had to amend the 3 strikes law and had an incidental effect on adult criminal sentencing, this court would have said that's still within the single subject of juvenile justice.
What about Brosnahan and Raven? I mean, you haven't talked about those cases because I assume those are worse cases for you. But, I mean, look at Brosnahan. I'm just going to read you the list of provisions. Constitutional provision limiting the exclusionary rule, abolition of the diminished capacity defense, a statute providing 5-year enhancement for each prior felony conviction, prohibiting commitment to the youth authority for certain individuals who have committed certain serious felonies, requiring public safety to be the primary consideration for granting bail. This court held that all of those are reasonably germane to another. So presumably under that standard, unless you are arguing for a different standard statutorily than constitutionally, an initiative could have started with any one of these and amended within the scope of the statute to include all the others under Brosnahan. How is this? I mean, that is way less related, in my view, than what has happened here.
I'm not arguing for a different standard. I'm arguing for a different application. The original filing sets the frame of the subject matter. And if the proponents choose a narrow frame, they're stuck with it. And in Brosnahan, had that
Why are
initiative,
they stuck with it? I mean,
because
but where do we divine that from the legislative?
From the statute, which says you must be reasonably germane to the theme, purpose, or subject of the initiative measure as originally proposed. And so while using the single subject words, the initiative, your subject matter is established by the original filing. So let's say, for example, I've file a school bond measure because I believe quality schools are an important factor in quality education. I don't think many people would disagree with that. Could I then, on the 35th day, add in merit pay and teacher tenure to that initiative? Because that affects quality education as well. Isn't that a different subject?
I'm not sure you couldn't.
I think that's exactly...
I'm actually not sure you couldn't. I mean, as Justice Corrigan read to you, the original measure here, in its terms, was intended to, quote, ensure that California's juvenile and criminal justice systems effectively stop repeat offending and improve public safety and ensure that the resources of those systems are used wisely to rehabilitate and protect public safety. I don't know how much broader you could frame that lens.
Yeah, but I don't think you should rely on the findings and declarations or statement of purpose in the initiative to determine what the subject matter
Then what
is.
should we rely on?
The text. The law is proposed
And
to be
so
changed.
do you think that there's a disconnect between that statement of findings and purpose in the text of
Yes,
the original initiative?
absolutely.
And where is it?
It's in Welfare and Institutions Code Section 602, which was proposed to be amended, which applies to, quote, any person who is under 18 years of age, close quote. It applies to Welfare and Institutions Code Section 707, an offense committed, quote, when he or she was 16 or 17
That doesn't
years of
come
age.
within the scope of the purposes that were read earlier?
Of a constitutional amendment that gives a right to parole to 120,000 people in state
It may
prison
not be a good idea.
or credits. That's
well,
not
let me go
related.
back to the purpose of this legislation. Is it your concern that the proponents, having amended it so late that the public can't comment, that the proponents are deprived of comments that might improve it, which you did reference? Is that your concern?
That's certainly one concern. The other,
Also your concern that somehow the public has been fooled? Or is it just your concern that the amendment doesn't follow the precise language of what's permitted under the law?
It's both, Your Honor. I think with respect to the process, not only was the public deprived of their opportunity, the legislative analyst, instead of having 50 days.
All right, so it's legislative analyst, because it's already been suggested that this legislation was not for the benefit of the public. It's been suggested it was for the benefit of the initiative process and the proponents.
I think it's also, it's for both. I think that there's a public benefit and there's a benefit to and the public benefits from this process as well. When the legislative analyst has 50 days to analyze a very complex.
So that sounds like the main concern, the short-circuiting of the opportunity
Absolutely.
to do an accurate and informative analysis.
So those are my concerns within the process.
But was there, in fact, a problem in this case?
We don't know. Because the legislative analysts actually didn't turn in their analysis in 15 days that they had. They were a day late.
Your thought of that too, though, because they provided a provision that said in the event that the legislative analyst doesn't meet the 50-day, there's an option for an opinion by the parties.
And that would be harmful to the public because the legislative...
It would be harmful to the public. It's statutorily provided for.
But it should be used in a rare situation, not routinely. The legislative analyst analysis, the fiscal element of that, is actually part of the title and summary that is printed on the top of every petition. And so if we're going to create a situation where, because we're only giving the legislative analyst 15 days instead of 50 days, and the legislative analyst is then is more frequently going to not render a decision, we've now made the process worse, which is where I started this argument.
Did the legislative analyst object during the hearings and the extensive work done on the evolution of this bill?
Not that I'm aware of, but again, looking at the situation here, you have the legislative analyst who had spent 35 days analyzing a juvenile justice initiative and the changes that it would have made to 11 juvenile justice statutes.
So I suppose we
And
are
then we're
in fact
told-
interpreting a statute for the first time. And as you can see, we're not saying whether or not the policy behind this proposed ballot initiative is good or bad, as Justice Corrigan has referred to, but we're trying to understand what the legislature intended. And we know that the legislature gave great thought to eventually what turned out to be this statute, because there's legislative history of vetoed bill, there's discussions, there's committee analyses. So the question for us is, how do we apply that? And so I wanted to ask you a question about what you had said earlier, and that is you're not looking to change the reasonably germane to purpose, theme, or subject matter standard, but you're looking to change its application. But when the legislature imported that standard from the single subject case law, they also imported its application, and its application is that this standard be applied in a lenient and accommodating manner. How would you change that application?
I'm not sure that I agree with that, Your Honor. First of all, they didn't just incorporate the standard. They limited it by use of the term as originally proposed.
Okay.
So that's one factor.
But that's just
secondly,
that's just what you compare it to.
Correct.
So when we get a single subject case, we're comparing it internally. This is an external comparison.
Right. So the other distinction is that this is a procedural step in the initiative qualification process. The single subject rule is a substantive challenge to usually an enacted initiative measure. So under prior cases, when we're talking about procedural steps, the court has historically said, you got to follow the process. And what was the consequence of this? You talked about it with Mr. Harrison. The only consequence here is if the Attorney General would have said, now, this constitutional amendment that changes the adult criminal justice system this much is not reasonably germane to this juvenile justice provision that was filed. All that would have happened is they would have had to submit a new initiative, filed another filing fee, and added 30 days to the process.
The Attorney General closed his remarks by saying there was no public harm. What is your position?
There absolutely was public harm. In addition to the lack of any public comment period, in addition to the truncating of the time period allowed to the LAO and the Attorney General to do the work that they had to do, if you allow a bait and switch like this, you're creating an incentive for people to do just this.
I guess
submit an initiative that it's not going to raise too much fanfare.
I think that the notion of harm here is a very slippery one because it just depends on what baseline you're measuring the harm against. You opened your argument by suggesting that we're now worse off under your opponent's interpretation of the statute than we were previously. I would suggest the legislature would beg to differ with your assessment, which is that they balanced a set of considerations, not simply the idea of having the public comment, but also leaving proponents with enough discretion. And I think it's telling, for example, that the statute specifically says that the public comments shall not be displayed to the public on the Attorney General's website during the public review period. Presumably, you could argue that that harms the public. Surely it does. It deprives the public of even knowing what each other is talking about with respect to the provision. But the legislature made that determination presumably because they thought that they wanted a degree of public input to the proponents, but ultimately left the proponents in the driver's seat as to what to do.
Yeah, I believe
why else would the legislature, in such a bald and I think non-public informing way, prohibit the Attorney General from displaying comments on the website?
The purpose for that...
Why would they do that?
Because they didn't want to make the Attorney General's website a public forum to debate, the merits or demerits of an idea or the proponent himself and turn it into a circus. What they wanted it to be was focused. What they wanted it to be was substantive comments.
How do we know that? I mean, that you can say that, but I mean, is there anything in the legislative history that indicates that they were thinking deep thoughts about really how the website was going to be used, other than to say all the comments only go one way?
I think you have to surmise what their intent was, but I don't think you can say that the fact that they weren't...
a little bit more than just to surmise.
I understand.
We all know that occasionally in these arguments there's a reach, but whole cloth is maybe a bridge too far.
Well, there's evidence in the record that they didn't want to create a public forum. And I think you then have to say, well, what was the purpose of this entire scheme? And this purpose was to improve the product. It wasn't necessarily to have a debate about the product.
And isn't it an improvement that that there be this, from the old regime? I understand this may not be the bill you wanted, okay? And there are many other perhaps even better ways to structure the initiative process. I don't know. I mean, people have studied this. But the legislature chose this way, and I don't think it can be said that they simply damaged the process or they didn't improve it. The improvement they sought was simply a coordinating function, perhaps. I'm just positing. Meaning that they set aside this little interregnum, right, 30 days, 35 days, or whatever, and they enabled the public to, they enabled initiative proponents to kind of out their proposals, and other initiative proponents or would-be initiative proponents who might have had something similar to say about a subject, reasonably germane, similar to say about a subject, could say, oh, I see you're about to do X, Y, and Z. And maybe there's 3 or 4 other groups that want to do something on loosely related subject. Instead of deluging the public with 3 or 4 or 5 or half a dozen initiatives, they enabled a transparency process so that those people could get together, figure out what was important to them, because maybe those people would think they have a better chance of getting some of what they want if they are simply united behind one initiative than divided among 6. And that's a service to the public, because who wants to read a ballot? I mean, I don't. I'm a voter.
So, Mr. Hilton,
we all have, so that's an improvement. It's not the improvement. It may not be the best, but isn't that an improvement?
I'll answer.
may answer the question, make concluding remarks,
Thank
and then
you.
your time has expired.
You have to compare the new process by SB 1253 to the old process. The old process, if it had been in place here, would have been a new filing. The clock would have started all over again. Everybody would have had their statutory time period to do their job. The LAO would have gotten the full period of time. The Attorney General would have gotten the full period of time. The addition of public comment is new. You talk about transparency and that the purpose of this was so that people could put it out there and not hide. This was hidden. This constitutional amendment was hidden. This far-reaching change in constitutional law that creates a constitutional right of parole that takes power from the legislature to decide when prison credit should be granted or not granted or withheld.
Do the voters have a fair opportunity to vote on this?
Should the process have taken place as intended? The answer should be yes. Had they followed the process, would the governor be able to qualify his initiative for the ballot? Most assuredly, and the voters would have an opportunity to do that. But the harm to the process occurred at the very beginning of what SB 1253 was intending to do. And so I would argue that this application is actually more harmful than the statute that existed prior. With that, I'll conclude.
Thank you, Mr. Hilton.
Thank you, Your Honor. Briefly, to the extent the amendments were hidden, they were hidden in plain sight because they were posted on the Attorney General's website for a period of 30 days before the title and summary was even issued.
What about those 30 days? Those 30 days didn't allow comment.
Let me clarify that the public comment button that's on the Attorney General's website when an original measure is filed was not there for the amendments. What was there was a copy of the amendments along with the proponent's contact information. So during that 30-day period, members of the public could have commented the proponents directly, as 2 of them did here.
There is another 30-day period.
That 30-day period comprises 15 days for the legislative analyst to prepare the fiscal analysis and an additional 15 days for the Attorney General to prepare title and summary.
But there's no public comment.
There's no public comment button. Let's be clear about that. All we're talking about is a button on the Attorney General's website. The comments are shared only with the proponents.
So if someone has a complaint that this constitutional amendment is changing or changing statutes that originally passed by the legislature and now they're in the executive branch, isn't that a problem?
They were free to contact the proponents directly, Your Honor, as 2 members of the public did during that period. Ultimately, there has to be some end to the public comment process. The legislature declined.
But isn't that the purpose of the public comment process, to comment on the proposal? You now have an amended proposal with no public comment. Nobody can say, wait a minute, you're changing the legislative authority into the executive branch.
Your Honor, the legislature made the determination that there was a 30-day public comment period and that following that there were 5 days for the proponents to make amendments. It didn't then say, and if amendments are made, there shall be another 30-day public comment period. The legislature's choice was to draw a line there and say from that point forward, the measure can go forward. The public has ultimate control over whether or not to approve the measure. There are multiple points of time in which the voters can indicate their approval or disapproval, but there is no second public comment period.
With respect to the theme, purpose, or subject of the original measure, counsel on the other side emphasized that the fairest reading is that it was about juvenile justice. But did the original measure make any changes in adult criminal justice?
Absolutely it did, Your Honor. It, as Mr. Hiltak made clear, made very significant changes to parole eligibility for individuals who committed their crimes before the age of 23. It made them eligible for parole, notwithstanding enhancements, consecutive sentences, or three-strike sentences.
The governor signed this bill. He quoted the bill's supporter, and he said this: "It enables broader debate, public review so that measures can be modified before they go on the ballot, avoiding unintended consequences, and would give voters a chance to address the flaws if there are problems with the language." Where is the public review?
The public review consisted of that first 30-day period, Your Honor.
Which no longer exists because this amendment was plugged in after that passed.
The legislature contemplated that substantive amendments could be filed after the close of the public comment period and declined to provide an additional 30-day public comment period.
So, Mr. Harrison, your time's expired as well, but you may make concluding remarks.
Thank you, Your Honor. Just one quick final point. A question was raised about how the court goes about defining what the subject of the measure is. In fact, the court can look to its own jurisprudence, where it traditionally looks to the findings and declaration of purpose of a measure, as it did in Mandalay, to define what the subject is. And in this case, the measure, both versions, make exquisitely clear that they're about rehabilitation in the criminal justice system. Thank you, Your Honor.
Thank you, counsel. Matter is submitted. This is the matter of Baral versus Schnitt.
Thank you, Your Honors. May it please the Court, my name is James Wagstaff. I'm appearing here on behalf of the appellant and the defendant, David Schnitt. The issue we're presenting today is one that is recurring in the appellate courts, and it's whether a plaintiff can insulate himself from the powerful and deterrent effects of the anti-SLAPP statute simply by styling a count in a complaint that combines protected and unprotected activities. Under California's anti-SLAPP statute, and we start with statute, the court may strike a cause of action arising from any act in furtherance of the person's free speech or petitioning activity. So the beginning of our analysis, of course, must be, what does the term cause of action mean? And our position is that it must be interpreted consistently with the way this court has interpreted that phrase since 1851 in multiple contexts. That is, you ask yourself, not how does the plaintiff style their complaint, labels they give to things. We look at the primary rights that are at stake in a case, and if a primary right is at stake, it equals a cause of action.
What was the cause of action here? Well,
there were two causes of action, Your Honor, two primary rights. The first cause of action dealt with in particular, the Livet claims. That is the claims about freezing out Mr. Baral from the IQB Livet transaction. The injury was that he was wrongfully prevented from doing that. Certain advantages allegedly were gained, and therefore, by the way, that transaction's over. That's one cause of action. The other cause of action or primary right, Your Honors, is the Moss-Adams audit claim. That is, for which there is a relief sought here. in paragraphs 43 and following of the complaint. That's an injunction. That related solely and completely to reputational injury that is sought on an ongoing future basis to stop that alleged reputational injury. And the gravamen of that cause of action is injury to reputation. So the question becomes, therefore, whether the Mann decision and its half of its progeny is in fact something that compels the determination here. So we start with the notion that if a primary right, as defined by this court repeatedly, most recently in Misogen and Crowley, where the court has rejected a same transaction occurrence analysis and said we're sticking with what we've been doing for 150 years, a cause of action is a primary right, it means the freedom from a particular injury. It does not mean the label. It does not mean the remedies that are sought. It does not mean a count. And, Your Honors, it does not mean evidence. The concern here is we'll be slicing and dicing all sorts of complaints. It doesn't mean evidence. It means what this court told us in Misogen, or Mycogen, I haven't got it yet. It tells us that there's a duty owed to the plaintiff. That duty is owed by the defendant to the plaintiff, and there's a wrongful act for which the plaintiff seeks some recovery or compensation.
Can a single primary right be violated by more than one wrongful act?
Yes, absolutely.
So if that's the case, then if we adopt your view and follow a primary right approach to this question, don't we wind up in the same pickle that we have been in up until now, because you could have one wrongful act that involves petitioning activity and one that does not?
No, Your Honor, we don't, and I'll tell you why. Because if we step back and eliminate the labels, here, as this court has done both in res judicata and summary adjudication and demurs, this is nothing new. I do summary adjudication motions all the time. The statute says you can get rid of the whole case on summary judgment or a cause of action. And you look not to the individual acts alleged or the evidence. You look to see to what extent there's a separate injury being pled from a duty. That there might be different acts that lead to it. We ask ourselves, is there a cause of action? Here, we don't have to do any guessing in this case. Here, if you turn to the record at 368 and following, you can look at the complaint. This is a case very much like the city of Colton, in which there was smushed. I've decided I've used the word smushed. I looked it up. There's a word.
Really?
Yeah, there is. Smushed, put together. My kids say I should use the word mash, like mashup, like music, but I'm not that modern. And so, smushed together by the unilateral choice of the plaintiff, two separate primary rights. The complaint itself tells us that. If you turn to the complaint, paragraphs 28 and 29, there is one part of the supposedly same fiduciary duty claim that is aimed solely at the falsehood, the alleged falsehoods of the audit. And paragraphs 28 and 29 talk about correcting inaccurate conclusions, falsity. And importantly, paragraph 43 of the complaint tells us that the plaintiff is alleging that he has suffered great and irreparable injury, entitling him on the Moss Adams part of the case to an injunction. The only injury he's asserting is that somehow the Moss Adams audit was false. So let's try this out. We have some archaeology here, Your Honor. We have an original complaint in which there were two separate defamation causes of action, which were stricken, and they didn't go up on appeal. They've been reinserted artfully, but let's imagine that in that first complaint, they didn't use the title defamation or slander. They simply kept typing. It was all under the category of fiduciary duty. It would be a complete end round the salutary purpose of the anti-SLAPP statute if someone by smushing could avoid the ability to have that case stricken when it arose from protected activity.
But take a step back, counsel. If you have a smush, as it were,
okay,
what precisely is the right way to disaggregate it, and what's the right unit of analysis?
The primary rights analysis, Your Honor. Exactly, and nothing unusual here. We've been doing it for, I'm going to say decades, because I've been doing it for decades. I had red hair when I first appeared in this courtroom. I don't anymore, because I color it white now. But the answer is, what happens is on summary adjudication, we do it all the time. The court has to decide whether to have summary adjudication.
The example you gave, you said you're going to steer clear of slicing and dicing allegations and evidence in the complaint. And in answer to Justice Cuellar, you said this is the fundamental unit analysis is the primary right.
Correct.
How is that distinguished?
From evidence? Sure.
From allegations and evidence?
Oh, sure.
It sounds like you just enumerated a couple paragraphs of the complaint, which sound like allegations.
Oh, no,
to me.
not at all, Your Honor. May I, both two questions. Let me answer both of them.
Yeah.
First of all, with respect to evidence, This court in the Episcopal Church case said there's times where certain allegations just lurk in the background. They're not what the person is suing for. You cannot find a single anti-SLAPP case in which they said it did not arise on the first prong when they were seeking a remedy. Here, paragraph 43 and 51, this is not just, hey, by the way, it was a false audit. That's part of my complaint. It was a allegedly false audit, which we want injunctive relief on.
So it's a basis for recovery.
It's
not just context.
Exactly, Your Honor. It's not just an allegation of, what time of day it was. And importantly, it's different times. The Moss Adams audit was at one point in time, and the supposed freeze-out claims, which are already over and they're seeking damages, are another point in time.
So can you define primary right then? Did Justice Corrigan move you closer to a definition, a basis for recovery?
No, I'm going to define it as Your Honor defined in Misogen. There's nothing new here. It has to be a duty possessed by the plaintiff that the defendant in a wrongful act breached, to which they seek some relief. If it's a different injury, then it's a different cause of action. Interestingly enough, Your Honors, I was thinking about this. I read Misogen, and sometimes I like to look at the cases this court distinguishes and says that's different. Take a look at the Title Guarantee Trust Company case cited in Misogen with approval. This court's decision in 1938, in which the court said, while Misogen, they were just seeking different relief, so it was the same cause of action, damages and specific performance. That's not a different primary right. There was one claim, which was specific performance to get land for default on an unpaid debt. And the other one was collecting the unpaid rent that had been accrued while they wrongfully possessed it. This court held, with approval in Misogen, those are separate and distinct. They're separate and distinct because they're different primary rights. So the primary rights analysis, which this court is engaged in for literally over a century, is something which you look to see whether there is a duty, a breach, and are they seeking relief on it, meaning a different harm or a different injury. In this case, it's not just allegations. And I'm holding it up because in this case, paragraphs 28, 29, 31, 43, and the prayer. The prayer itself says we want an injunction as to the Moss Adams audit to make them, compelled speech, go talk to them and correct it or obtain the correction. So in paragraph 3 and 5b of the prayer, this is not just some extra allegations of wrongful action, Your Honor. This is alleged as a separate primary right.
So if I can sort of move us away from the facts of this case, which I think are a little bit unusual in how the complaints have transformed over time. But it seems to me that there is some space between having extra allegations that are just incidental background information, as in the Episcopal Church case, and having allegations that are sort of front and center as a basis, a standalone basis for the injury claimed. It seems, sometimes you sort of put together different pieces of wrongful activity and, together, they work together to provide a basis for assigning liability to the defendant. So I think the difficulty for us will be to try to figure out where the appropriate line is between purely incidental allegations and allegations that are the sole basis for assigning.
But if the guidance from the court is established law, then the primary rights theory has been with us for a long time and it's used. Let me give 2 examples, if I could, Your Honor. Let's take the Cho case. In the Cho case, where the court, I believe, correctly held you can't smush to avoid the anti-SLAPP statute by labeling, the Cho case, you had 2 defamations. In one defamation, you had it to the EEOC and to the government, and the other was to other employees and the employer. The ones to the employer were not protected. The ones to the government were as petitioning activity. They were smushed together. Had we applied the Mann rule rather than what the Cho court did, there could have been no anti-SLAPP motion. By the way, there could have been no summary adjudication motion. And by the way, since this court may tell us we can't have in limine motions that get rid of whole causes of action, we're in trial. The entire purpose of the anti-SLAPP statute is defeated, was to get this resolved early, to discourage those who have unmeritorious claims or causes of action. Let's take another one. I think the City of Colton case is an excellent example that addresses Your Honor's question. In City of Colton, you have, again, a smushed cause of action, the 4th cause of action, in which the allegation, one, is that he engaged in an act of city suing someone for an act of bribery. Happily, that's unprotected. And for bringing a lawsuit where they're trying to gain advantage. They seek restitution from the bribery. They seek an injunction to the lawsuit. They were smushed together. The City of Colton case, again rejecting Mann, says, of course you've got to deconstruct the separate causes of action because the statute says so. And the bribery cause of action is different because that's a different injury than does the claim for the lawsuit. The lawsuit's protected activity. Therefore, since it's protected activity, it's a separate cause of action, even though it's been smushed together or mashed up, and therefore the cause of action gets separated by the court. And the courts do this. It's not hard. Now, this court's done it already. You did it in Taos versus Loftus. Whether it was done with great knowledge of what man was going to do or not, you did it. In Taos versus Loftus, you had a single cause of action. You had many, but for purpose of our discussion, what the court did, a single cause of action for invasion of privacy. But you had 4 different acts of invasion of privacy that weren't just evidence of wrongful acts. They were separate, discrete. You could sue on them alone. Therefore, they were de facto 4 separate causes of action. What did the court do? Did the court do what the Mann court contemplated, which is if any one of the 4 survives, you can't do it? No, Your Honors did what First Amendment law has been doing since Sullivan. You took them as 4 separate causes of action, said 3 of them don't survive, 1 does. And as the amicus brief, I thought so thoughtfully set forth, that was of real value. Because when it went back down, the case was narrowed down, the parties were able to settle the case, and the anti-SLAPP statute was confirmed. So what happened? In Oasis West, this court cited Mann in a preliminary statement of the law. Oasis West did not involve a mixed action. We'll say it again, Oasis West did not involve a mixed action. When it came out, there was a lot of hubbub in the legal community because the allegation was a lawyer had basically switched sides and was arguing against his client in a public setting. They had 3 theories, negligence and breach of fiduciary duty, etc. But the court cited Mann, which had no application to the case at all. I think it's of some significance, although I don't go through that back door at the end of this hearing to know what goes on. But nobody cited Mann, and the issue was never raised in any of the briefs or the oral argument. So I suggest that the court wasn't intending to overrule Taos v. Loftus. It was simply having a preliminary dictum statement, which has created some confusion. I think if you're asked the question how to do it, Justice Needham's opinion in Wallace, while he at the end says Oasis West seems to tell us we can't do this, the entire opinion is based on why it would defeat the purpose of the anti-SLAPP statute dramatically if someone could smush, avoid the statute, and keep that case in there. So the argument is, boy, it's going to be really hard to do. Well, I mean, that's true of I have some of my students here from my civil procedure class. When we teach what a cause of action is, it takes a while to talk about primary rights, but I read 2 long law review articles on it. Judges have to do it every day on demurs and summary adjudications. So we do it. In this case, it is a separate cause of action, but I don't think that Oasis West was intending to change the law in that regard. So I think if you look at what happens in these situations. Now, what about what really happened here? I think was it Groucho Marx who said, who are you going to believe, me or your own 2 eyes? The evidence here, in this particular case, is that the plaintiff himself routinely was able to describe these as 2 separate claims. If you look at his declaration, the anti-SLAPP, that's the plaintiff at 138 of the record and following, he describes the live-it claims and the defamation claims separately. You don't have to stop there, because if you look at his opposition to the motion to stay, so now the court denies the anti-SLAPP. It goes up right away, and my side says, let's try and stay this. Let's not do discovery. If you look at the record at 1170 and following, the plaintiff himself says on page 1179, the live-it claims are also not stayed because they are not embraced or affected by the appeal. Your Honors denied the stay request in this case. The theory that the live-it claims are separate from the Moss-Adams claims. If they were all embraced and all the same wrongful acts and just a continuum, then that would have been a different deal. And in that very opposition to the motion to stay and the opposition here, the plaintiff has said just that. So
can I ask you, so would it be a fair summary of your position that you are not suggesting that the anti-SLAPP statute be used in this circumstance to strike allegations, factual allegations from the complaint, but instead factual allegations concerning protected activity as they are incorporated into claims for relief? So insofar as the factual allegation of protected activity provides a sufficient basis for assigning liability to the defendant, you're saying that it should be?
Absolutely, Your Honor. No one's suggesting that we start slicing and dicing evidentiary allegations.
You're asking us to adopt the Taos rule?
I am. I'm asking you to do what you did in Taos, which is to allow you to, if you have different primary rights, And by the way, the amicus effort is there. Defamation has, at common law, always treated every defamation as a separate cause of action. So that it solves the problem, as the amicus brief says, so we don't have to worry about their hypothetical of 11. I mean, I think that their hypothetical illustrates the problem. I mean, the purpose of the anti-SLAPP statute was early determination, shift the fees. When someone's sitting in my office thinking about a plaintiff's case, they should know about that because let's not take on the meritless claims. So the argument's made, well, it'll be a lot of extra work, putting to one side whether that's required or not. Actually, it won't be. What's going to happen is once man is clarified as not the law, you're going to have people not engaging in what we've been calling in many ways, we've been calling it the man loophole. You want to get around the anti-SLAPP statute and the attorney's fees exposure and all the things that the legislature says we need to do? Then just put it in a cause of action with unprotected activity, and then no matter how you label it, you're safe. Then it also, I think it'll stop some of that. In addition, we'll spend less time, trust me, we're doing it, we'll spend less time on anti-SLAPP motions having to try and also get rid of the unprotected. Because under man, if you can get rid of both of them under prong 2, you're in. As long as so we're not going to do that. So I think it's going to actually make it more efficient and clear in that regard. Because, and by the way, as the Wallace court said, that would really defeat the purpose of the SLAPP statute. The SLAPP statute was not intended to allow an early elimination of an unprotected claim. Yet as a practical matter, if that's the case and they smush it and we get rid of both of them, now the plaintiff has faced an early summary judgment motion de facto with no power to amend because the courts have held you can't amend your way around an SLAPP statute, which is correct, of course. So then you'd actually be advancing summary adjudication, harming the plaintiffs in that regard, as I see it. So in this particular case, the injury as to the claims we've identified, Your Honor, only flow from the falsity, which means that had they simply called it a separate cause of action for injunctive relief / compelled speech, we wouldn't have any trouble. So in this particular case, Your Honor, therefore we say, what should we do? Well, prong 1 satisfied. The Moss-Adams audit arose from litigation-related activity. It was a forensic audit sought for the purpose of getting information in connection with litigation, and you don't have to believe me, there's only one thing in the record on it, and that is Mr. Schnitt's declaration itself, where he says at 58 and following and 216 and following, that's what he was doing. He was hiring them for the purpose of looking into this embezzlement by one person and the possibility that they would have other wrongs in anticipation of litigation. He says so. He says so in that regard. Whether or not Moss-Adams would ever testify is not the issue. I hire consulting experts all the time who won't testify, but they're still part of it. I mean, the Block case is a good example of this for the privilege. The DA hires a toxicologist to give a report on blood in a case. The court holds, quite correctly, that arises out of the litigation, even though the litigation may not yet be filed. So in this case, this court has held seeking an attorney arises out of litigation. This court has held the filing and funding of litigation arises out of litigation. That's the Rasheen case. The court has held in Hatchburg and others that the communications to investigate the feasibility of filing a lawsuit is protected. The Briggs case, one of our leading cases out of this court, held that the anticipation of litigation is there. So prong 1 satisfied. And prong 1 satisfied because this is clearly not an incidental evidentiary allegation. They're seeking relief in the form of an injunction in this case. There's no question about that. In the Haight-Ashbury case, for example, there were 16 subparts of a breach of fiduciary duty claim, 2 of which were protected, 14 of which allegedly were not. And that's the situation where if that's severable and has a different injury from it, if all it is an evidentiary allegation, that is, it's not a primary right, well, then the statute says it has to be a cause of action. I like reading statutes because it tells us what to do. Someone asked me, is there any legislative history? I was listening to the last argument. Well, there is no legislative history of what the word cause of action means. I think we know what that means. And I want to highlight this court, as many professors, just call cause of action claim. Those 2 words become interchangeable. Count's different. Count's how the plaintiff styles it. And I'll tell you why. In the federal rule, I practice a lot in federal court. Federal Rule 8 said we don't want to call it a cause of action, we'll call it a claim for relief, but it means the same thing. So cause of action and claim are overlapping because the word claim is used in the statute. So now we go to prong 2. So if it arises from and it's not incidental, which it's not, we go to prong 2. Here, the court could have and should have granted any SLAPP, deconstructed the cause of action, that's easy to do here, and granted, on prong 2 said that the 47B litigation privilege applies. The Moss-Adams audit was undertaken in anticipation of litigation, and therefore, that was not only protected activity, it was subject to an absolute privilege, even if false. The Hagsburg case tells us that. It's the one that said to investigate the feasibility of a lawsuit is covered by 47B. The Block case, which is the one dealing with the toxicology report. Your Honor's decision in Rubin. In Rubin, it was an issue about someone making statements in connection with retaining a lawyer in anticipation of litigation. Even if litigation doesn't get filed, if it's reasonably anticipated, as it was here. And Your Honor's decision in Rasheen, where someone filed an allegedly false declaration to get some collection efforts, and the court said that's privileged. It's an absolute privilege. And therefore, in that case, we have prong 2 being satisfied as well in this particular case. This is not, my dad used to tell me, today is the 20th anniversary of his death. My dad used to tell me, he was a lawyer, that sometimes we lawyers get in French debates. We debate things that don't matter. It matters here. Not only because the SLAPP statute should be employed. In this case, it will change the scope of discovery. Think of all the depositions of the Moss-Adams people that are not relevant for purposes of whether he was frozen out on the Livet claims. It's just those alone. There's a reason, like there was in Taos, to do this. The truth of the underlying audit, when the court strikes this truly separate primary right, won't have to be the subject of the lawsuit. The lawsuit, because Mr. Barral ultimately went along with the sale. He made millions of dollars. He's not here in any way challenging the Livet sale. He's simply suing for retrospective damages, saying allegedly that Mr. Schnitt hid information from him during that process and got a sweetheart deal. We'll let that work its way out when it goes back down in a more constrained way. The anti-SLAPP statute admittedly has some very strong teeth to it, which this court has enforced repeatedly in Briggs and Equilon and those cases. It says if it arises out of protected activity and the plaintiff can't meet their burden of showing the possibility of getting past, in this case, a privilege, we get it decided at the outset. Basically, with no discovery. Attorney's fees shift, and it goes on an immediate appeal if denied, and it stays at appeal. Those are powerful, powerful things the legislature has said, because it matters to stop strategic lawsuits against public participation or cause of action that arise out of protected activity. In this case, Your Honors, may I say that it is the archetypal example of an anti-SLAPP statute. It's based on free speech. It's based on alleged falsity of speech. If they get up here and they say, run through the hypothetical in the first complaint if they just got rid of the titles. Just got rid of the titles and just kept typing. Would this court be unable, because the plaintiff had chosen to style it as a single cause of action, would the defendant be unable to bring an anti-SLAPP motion? That defeats, by way of end round, the entire purpose of the anti-SLAPP statute. In this particular case, the primary rights analysis, which, like lots of legal things, may take a while to teach and a while to learn, gets employed by courts all the time. And if you don't understand it, you can read a good secondary source that tells you how it goes, like maybe one of those good books that tells you, but you don't need it here. This case wasn't a hard primary rights analysis. And the way you get there is you strike, and we ask the court affirm and strike the allegations in paragraphs 28, 29, 31, 36, 40, 43, 46D, 49, 51, 59, 60B, and 60C in the prayer, because those comprise the Moss-Adams allegedly false audit. By somehow eliminating a claim for damages and somehow no longer calling it defamation does not take away its essence, which is an effort designed to compel my client to speak and to punish my client for engaging in protected activity. If there's no questions, Your Honor, I'll save my time for rebuttal.
Good morning, Chief Justice and Associate Justices. I'm Gerald Sawyer. I represent the plaintiff and respondent, Robert Burrell. Now, I think that in order to put into context what you just heard from Petitioner's Counsel, I have an anecdote. A few weeks ago, I attended a Bar Association meeting that was devoted solely to the anti-SLAPP cases, talked about the Burrell case. One of the attorneys had got up before, about 400 attorneys, to speak, and he had a big graphic. It was a giant missile and a bullseye. And it looked like something out of the Wile E. Coyote cartoons that was bought from Acme Products. But the point is when he got up, he said, the SLAPP statute is a weapon of mass destruction, and I'm going to explain to you why it is. And he proceeded to go through the things that we know about it with respect to the automatic stay, the fact that it precludes amendments, the fact that it now requires that once the prong one is satisfied, that the plaintiff now must make this evidentiary showing with little or no discovery. And if the plaintiff loses, mandatory fees. If the defendant doesn't prevail, discretionary. And on top of it, automatic appeal. Now, taking that into context from it, here's what is being advocated by the so-called smushing rule. What he's really advocating is that anytime a complaint is filed, counsel are going to look through it, and any allegation that touches upon either free speech or the right to petition is going to trigger that anti-SLAPP motion.
And they will point to... Can I just ask you a simple question before we go all the way to mass destruction?
Yeah.
Let's assume that A is suing B, and A alleges that B defamed him in two ways. Number one, speaking against him somehow at a city council meeting, and number two, saying bad things about him at a card party. The first would be protected speech, and the second wouldn't?
Yes.
Okay. You could, A could allege, count one, defamation at the public meeting, and count two, defamation at the card party, right?
Yes, but...
And one of those would be, one of those causes of action would be subject to a motion to strike?
Actually, yes, that's correct. Now, you're using...
Real simple. He defamed me at a public meeting.
That's correct. But I'm not advocating, and we'll get into this, I'm not advocating a rule that we're changing the rules of defamation with respect to the evaluation of a statement.
I'm not suggesting that either. The second part of my hypothetical is, if we both agree that in the first part of the hypothetical, one of those causes of action would be subject to a motion to strike and the other wouldn't because it wasn't protected activity, what happens when A says, B committed defamation and I want recovery, and he defamed me at a public meeting, and by the way, let me tell you in paragraph 2 of my cause of action that he defamed me at the card party.
So
is your position that a special motion to strike would not lie against that cause of action?
No. If someone had muddled everything together, and it's not artful pleading, and when I get into the cases, we find a lot of inartful pleading going on.
We find a lot of inartful pleading going on.
I understand. So the point of it is that in that situation, if they brought the SLAPP motion and they laid out to the court precisely what portions of the sentences would qualify for a defamation claim subject to the SLAPP statute, that could be pulled out. Why? Because, again, it's not the labeling. It is a cause of action. Okay? So that...
I'm sorry. Can you stop right there? How do you determine what is the cause of action?
Primary rights, and there was a misstatement on that. We agreed. If you look at in our briefs, we're not disagreeing on primary rights. Where the rubber meets the road here is primary right analysis was never brought to the trial court. It was simply, let's strike these allegations. There was never any contention that it was a separate cause of action. In front of the Court of Appeal, primary rights was never talked about. The Court of Appeal then went through the analysis. And when you look at, and I'll get to your question, when you look at City of Colton, I think, and that's why I talk about the trenches versus I'm going to give you from the bottom up view in this case. The trial judge was quoted in City of Colton saying SLAPP motions are very, very, very difficult. It's right in the opinion. The point being, again, that in the context of this case, we're not advocating against the primary right doctrine. But what we are saying is that you still have to balance this when we get back to Mann, and I'll talk about our cause of action, because there was a misstatement on primary rights. The law on primary rights, so that I quote it accurately for you, is the following. Let me take you through this for 1 second.
And your source that you're going to read?
Yes, I'm going to give you the site. So the general test is from Gamble versus General Foods, 229 Calap 3rd, 893. The pin is at 898. Here's the test. 1, a primary right possessed by the plaintiff. 2, a corresponding primary duty devolving upon the defendant. And 3, a delict wrong done by the defendant which consists in a breach of such primary right and duty. Let me move on. Henderson versus Newport Mesa Unified School District, 214 Calap 4th, 478 at 499. A plaintiff's primary right is defined by the legally protected interest which is harmed by the defendant's wrongful act. Next, South Sutter versus Lee Sutter Partners, 193 Calap 4th, 634 at 659. The most salient characteristic of a primary right is that it is indivisible. The violation of a single primary right gives rise to but a single cause of action.
Well, and in that context is what is often brought into play in a discussion of the concept of primary right, right?
Yes, but here's the one that was missing. Let me give you the last one as I build up. The crescendo.
Okay, let me not get in the way of the crescendo.
So, Boblet versus Boblet, 190 Calap 4th, 603 at 610. Under a primary right analysis, the cause of action is determined based on the harm suffered rather than the particular legal theory or relief sought by the plaintiff. Now, let me drill down to my complaint on that, okay? I came in, and so you understand the backdrop of this case. I did not draft the first complaint. I did not draft the second complaint. They both were slapped, so my client was, quote-unquote, slapped silly in this case. I came in, and with respect to the amended complaint, I did what occurred in Fox Searchlight. I called opposing counsel, and I said, look, this case has been stayed. My client, we need to get on with the dispute resolution. Let's do this. I'm going to draft the second amended complaint. I'm showing it to you. If you disagree, and we had a back and forth. At the end, we abandoned the appeal. We released. They get all the fees that had been incurred. And the complaint at that point in time, the day before, after I released it, there's a little hedge. Well, I'm still researching things. So, and I had thought that at that time, because we were up at the deadline, that it had been approved. But all of a sudden, I get this hedge back. At that point, after it was filed, that's when then we get slapped. We get slapped at that point. The only law that's contrary is City of Colton. Now, I'm going to talk about the allegations first, and then I will talk about the cases, because I know that's what we're here for in the statute. The allegations. The labeling that was done is really short titling. We could have called them, A through C and D to differentiate. It was just easier because they had done the labeling that I fell down that trap, rather than trying to rename them so it would be confusing. A is that Bob Burrell was frozen out as a co-managing member of the negotiations with respect to the business. B is that he was frozen out with respect to being a shareholder in the new company that took over the business. The defendant became a shareholder. C is that Bob Burrell was not given an opportunity to become an employee of the new company. The defendant was. D, and that's what I worked with very carefully, was the following. Burrell was deprived of the right, after the fraud investigation report was issued, to submit any information to Moss Adams, to ensure that we did not run afoul of anything having to do with Rule 47. I crafted it as follows. We crafted it so that all we were asking the court for, and the remedy doesn't control, it was the freezing out of his rights as a co-managing member, and that's the dispute here. And so I crafted it as follows. A debt relief claim that deemed him to be the co-managing member and provide the following injunction with no consequence. Simply order Mr. Schnitt to not block Bob Burrell from submitting information to Moss Adams. It will be up to Moss Adams to decide what they want to do with it. They can do anything they want with it or nothing. And with respect to that, Bob Burrell will pay the cost of anything that's incurred. So there's no damage to the company. There's no damage to anyone. And it ties directly, when we suss this out, when we pull the taffy apart, it deals solely with the freezing out. And why is it that it deals with the freezing out?
The freezing out from the Moss Adams audit?
Yes.
Or the other kind of freezing out?
The Moss Adams audit is part of the whole freezing out. The Moss Adams, okay. So let me just explain this one allegation, because I think it's critical to understanding this case. As part of the sale, when the due diligence was done, Moss Adams did 2 reports. They did one report to look at what the books and records showed. When they saw something that was irregular, we had the fraud investigation. Schnitt ordered it. That's fine. After the report came out and there were things put in it that were negative to my client that he had no opportunity to respond to or do anything, Schnitt said, I will allow you to have access to them, but you've got to drop your claims. So what he was doing in this context, and that's why I tried again to separate it so you understand the allegations, was he was freezing him out again. He seizes control when he doesn't have the right. We're not talking an individual here, and that's the other layer that hasn't been decided, the complexity, because it's about the company. Bob Burrell says, I'm a co-managing member. I have a right just to submit the information. So it's not about reputation.
At the moment, we are not. This is hard enough without figuring out who's at fault and whose ox is gored and whether or not it was okay. We're really trying to focus on this very narrow question of pleading and procedure.
So let me address it.
Okay, good.
1, we're not advocating against a primary rights rule. 2, if you apply it to this case, you do not end up with 2 separate causes of action.
I'm sorry, so you began your discussion of this particular case by suggesting that you have a different vision of how the primary rights analysis ought to go from the other side, and it seemed to be, if I understood you correctly, a focus on the alleged harm suffered by the plaintiff versus the nature of the claim for relief. Did I understand that correctly?
That's correct. That's the law. And the harm.
And you can explain what difference it makes to focus on the harm suffered versus the claim for a remedy for the harm suffered.
Under the law, the remedy is immaterial. We can have one wrong that you may have damages, injunctive relief, and many things that flow from that wrong.
Okay.
So the point of it all is that in the context of the wrong here, the freezing out, it's to just say that it's the transaction and not the act afterwards to also benefit from the transaction is not looking at the allegations in terms of what the wrong is. The wrong all has to do with the rights of Bob Burrell as a co-managing member. When we look at the case law on this, and that's the key, and I'll give you the 2 outliers. They're very interesting. There's only 2 outliers, City of Colton and Cho. City of Colton started as follows when I look at it. City of Colton was one where we had a developer who bribed a city official and changed a public contract whereby that individual was able to change it so instead of him paying for certain work in connection with the subdevelopment, the city paid for it. The city cross-complaint, the developer, after being convicted, sued the city to enforce the original contract. And this is the one where the trial judge couldn't believe it, that all of a sudden he's confronted with a situation where a felon is suing the city to enforce a contract that was obtained through bribery. The city, whoever put the complaint together, did not do the best job possible as you look at Judge Richley's commentary on it. And the Court of Appeal asked for supplemental briefing. We had this cross-complaint that had an issue of fact about using litigation for this end that triggered prong 1. And so in the supplemental briefing in that one, the Court of Appeal was given 3 options. Option 1, go ahead and let it stay because you've got some merit to this, and that's the key on the statute in terms of the unprotected claim that's embedded in the cross-complaint, it stays. Number 2, go ahead and parse out the stuff that you think is protected away from the unprotected. And 3, dismiss the whole thing and let us replete it again. The court opted for 2. That's how we started, and it was a 2-to-1 decision. That's how we got here initially. Cho v. Chang now is on the trial court level. At the trial court level in Cho v. Chang, you had a situation where Ms. Chang claimed that she had been groped on 2 occasions in the workplace. The supervisor claimed I didn't grope her, and in fact what happened was she's making these complaints when I've complained about her work. So he cross-complained for the defamation claims. And it turned out in that complaint, the trial court looked at it and did what we're talking about, I think on a primary right analysis. It sussed out, at least if you want to look at it, if that's what they were doing, because it's not in the decision, so I don't want to overstate it. But they tried to pull out in Cho v. Chang, as I tried to reconcile it, those claims in the cross-complaint that they thought were protected versus the unprotected. It went up on appeal. The problem on appeal, even with the opinion is that the Court of Appeal affirmed it. But we run afoul in the trenches down below with the trial judges in having the time to really pull this apart. In this court, when you take the Kaus case and you have the time and the ability and the resources to go through 4 claims and write pages analyzing them to decide it, it doesn't work that way down in the trial court. It took us 10 months on my second amended complaint to have the slap motion heard. My point on this is, if the facts of this case, what I'm concerned about, even on your narrow issue, if the facts on this case is repeated, and any lawyer looks at it that's knowledgeable of the statute and tries to use it as that weapon of mass destruction, they will see that what I want to do is I want to glom onto anything that possibly touches, because then I have the ability to stop the case in its tracks and all the things that go with it. And that is putting a huge burden. In our case, the trial court was correct. They got a motion. They looked at the motion that said, we are parsing out these allegations. There never was a discussion at the trial court level of, no, this comprises a cause of action. The trial court shouldn't have to guess. The Court of Appeal then took it upon itself. And again, with prong 1, I disagree, and we don't have to go there because they reserve the right on the litigation privilege as to whether the individual has it versus the company in this context. The Court of Appeal punted on that, saying that will be an issue later on for the trial court. But by using the Hunter versus CBS, it then said, well, okay, we fall into prong 1. It then did its analysis looking at the causes of action as one cause of action. And it said that, again, we affirmed the lower court. It did even more work. Now, all of a sudden, when we come up here, primary rights, what you've got to do is you've got to pull it apart. I guarantee you that if you issue an opinion and you quote the facts whereby that lawyers can see that they move to parse allegations, you're going to end up with a lot more motions down there. They're heavy motions, and it's going to take even longer. And for what purpose? The statute's got a balance to it. And so I'm not arguing for labeling. In my case, I believe I did it properly. We have, for Bob Burrell, one cause of action. They've tried to dress up the motion. They put a tuxedo on a pig. It's still a pig. And so in this instance, I'm advocating to each of you that with respect to the Mann rule, we haven't talked about it. Everyone looks at Taos, and there's a lot of discussion on it.
Look, can I just ask you at the threshold?
Sure.
Are you suggesting we embrace the Mann rule?
Yes.
Okay.
Absolutely.
Thank you.
Because of many reasons, but number one, I put before the court, when we look at this, and that's why we're here, but these 2 outliers versus even the cases I sent up recently to you, we've got the Northern District Court using the Mann rule, the Ninth Circuit quoting the Mann rule, and on top of it, we even have another California appellate decision quoting the Mann rule. You've got published and unpublished 25 cases where everyone's falling in line, and you have these 2 outliers. And so, in my mind, I have to go to the facts because the 2 outliers, again, I think are somewhat unique. But I don't believe this. When they criticize the court and try to say it's dicta, or maybe some kind of someone spilled coffee on a brief and somehow the Mann rule ended up in the Oasis case, I don't believe it. Because with that case and with the analysis that the court did in Oasis, everyone's been following it. And all the scholars say that whether it was explicit because you didn't talk about mixed causes of action, the fact remains that everyone has fallen in line on those words. in OASIS.
How do you understand the Mann rule to comport with the primary right theory that you have agreed applies in this case?
Well, exactly. So let's use my case. The first three allegations that we've labeled the Livet claims are unprotected. Those claims are about being frozen out of the of the transaction with respect to Schnitt not allowing my client to participate. What we call the Moss-Adams claim triggered, at least for prong one, and I have my views on prong one, but it's a large catch basin in prong one, whereby there was an argument that this is tied to the litigation privilege because it has something to do with the fraud audit. And so the argument there is you've got a protected and an unprotected. The analysis is, because it's one cause of action, one set of primary rights, one duty, one wrong, the harm not to participate as a co-managing member, that the court simply looks, just as you did in OASIS. In OASIS, you quote Mann, and you only look at it's a legal malpractice claim, and your own decision says multiple acts. Mann is quoted, we're just going to focus it, we're jumping away from prong one, we're going to prong two. And you know what? We look at this one act, and it satisfies prong two. There's a probability of prevailing. End of story. Okay?
Is that not at least somewhat narrower than what Mann provides? It seems like Mann just stands for a somewhat different proposition.
Mann stands for the proposition on mixed causes of action, and I believe that it is a good law based on this court's ruling, this court's citation to it in OASIS, and many other courts following it.
Do you not understand the Mann rule to stand for the proposition that the only unit that is subject to a special motion to strike is the cause of action as pleaded in the complaint account, in the complaint?
I don't read it that way. That was the thing that, again, and I have to go, that's what I mean. I go to the words on the page. When I hear damage to Bob Burrell's reputation, I worked hard on that complaint. You can't find the word reputation there. When we talk about the Mann rule, there's nothing there that the court says, no, we're only looking at how it was organized by counsel. We're bound by how they put the words on the page. We don't use primary rights here. They don't say any of that. So it's an extrapolation. I think you used earlier speculation. It's not how this should be done. And my fear is the reality, and that's what is in the Court of Appeals opinion. And I don't have the luxury of someone looking at the cost on the system on this kind of a ruling.
So can you tell us, I think you've done a good job of laying out how this has been used in the outliers, and I've heard you answer that you don't read the Mann rule as indicated by Justice Kruger. So what would be your rule? If we were to write your rule, what would it say?
You mean I get the Sawyer rule as a matter of law? Okay, thank you. I think that my rule would be as follows. Number one, in the analysis, what is important, I didn't touch on the CBS case, because remember...
The rule you would have us write is...
Pardon?
The rule.
The rule.
The rule is that in the context of a SLAPP motion, that with respect to the analysis of what constitutes a cause of action, that we would apply a primary rights analysis, not how it was labeled. But at the same time, because of and why I was going to this, the caveat is, if the allegations are incidental, and that's what CBS says, we don't want to run into a situation where we're going to have everyone moving and treating it like a garden variety motion to strike. So the law is out there in CBS with respect to if the allegations are incidental.
But for incidental allegations.
Pardon?
But for incidental allegations.
Yes. Wow, I'm off the top of my head. So, yes, it would be but for incidental allegations. I mean, I would go back to the definitions I read you from the cases if I was crafting the rule.
Can I just take you back? Because I want to repeat back to you what I understood you to say.
That's fine.
And you would say that in the context of a special motion to strike under the SLAPP rule, a cause of action is defined by the primary right doctrine, and a SLAPP motion will not lie to strike incidental allegations.
Yes.
Right?
I'll give you the quote for that language. I mean, yes. I think that is, I'd have to sit, you're catching me off the cuff, but the rule is, let me read it. And again, this comes from Hunter versus CBS, Let's see if I've got the pin for you.
Don't worry about it. We can find
Okay, it's
that.
at 1520. Here's the quote. We assess the principal thrust, because you look at the gravamen of the claim. We assess the principal thrust by identifying the allegedly wrongful and injury-producing conduct that provides the foundation for the claim. If the core injury-producing conduct upon which the plaintiff's claim is premised does not rest on protected speech or petitioning activity, collateral or incidental allusions to protected activity will not trigger application of the anti-SLAPP statute.
So in part, this case turns on what allegations are collateral, right?
Yes. I mean, if...
And would it be fair to say that collateral allegations are allegations that would not be sufficient to support a claim for relief?
Well, in a mixed cause of action, I don't know if I would go down that path.
I thought you might not.
Because in that instance, I think we could have a situation such as this one, whereby on the freezing out and the tethering of a fraud report, as part of that conduct, I believe it's all one cause of action under a primary rights analysis.
Because?
Because the primary right was Bob Burrell's rights as a co-managing member to be involved in what? In the management of the fruits of his investment and efforts for the business. He was entitled as a co-managing member to make decisions for the company. That included whether to sell, whether he would be in on a stock sale, whether he would be an employee,
well,
and what information.
I realize you're listing all the things he could have done if he were included as an equal co-manager, but your primary rights theory that you've described, I think, goes back to your argument that we need to focus on the harm suffered.
Yes, and that's what I was trying to...
That's what you're describing. Freezing out meant this whole list of things he couldn't otherwise participate in.
Yes, and that's how it was analyzed by the lower court. And that's when I tried to put this together, you know, and never dreaming that it would still be arguing about it. That's all I was trying to do. I was trying to separate from anything that had to do with touching on the free speech or the right to petition.
Well, if we look at harm suffered, at some point, you don't just get to come into court and say, I suffered harm. You have to make specific allegations about what happened that caused you harm, right?
Yes.
Okay. And if one of the allegations on which you rely to demonstrate that your client was harmed is an exercise of protected speech, shouldn't that be within the anti-SLAPP statute?
Again, it depends if it's incidental or not. That's where we pull it together.
If you're, and I appreciate that it's a little illusory, but if your claim is based, your claim for recovery, your assertion of harm is based on protected activity, then it seems to me that because you're seeking relief as a result of that activity, you're claiming you were harmed by that activity, that's a classic anti-SLAPP situation.
Yes, generally, but not in this context. That's where we go back to the litigation privilege. The report was obtained.
Okay, so wait a minute.
That's what triggers prong one in our case.
And that, are you asserting that that the activity asserted was not protected activity?
Yes, that's where I disagree with the lower court. In other words, if you look at the record again, it was simply at the trial court they tried to parse allegations, denied basically. Court of Appeal then wants to analyze this, and what did they do? And I could go into this. They had to find there was no communicative conduct because we're not talking about the report or anything that was said.
Well, counsel, I don't mean to derail you, but
it's okay.
It's one that we're trying to decide what to do when there's protected activity alleged. I appreciate that you want to maintain your ability to argue that this activity wasn't protected, but that's a different kind of question than what we're trying to decide here.
I understand. I think that if you're grappling with, today, if the issue is that the court would like some submission on language in terms of suggestions, because that on how I would go about it, or both sides to take into account, I'm happy to do it rather than orally on the spot. I've tried to glom onto sort of what the cases are and how it's spelled out. I do see a danger, a big one, in terms of this statute designed to get rid of meritless causes of action and lawsuits and being turned into just a motion to strike to attack these allegations because it stays the action. And so in this case, and I'll close, the thing to keep in mind is before all the states, when we had a little window, was going to be able to get depositions finally. When the Court of Appeal put the stay back in, that went off the table. Recently, in this case, the reality is I've been trying to get them, and now all of a sudden can't find any of the people we need who are involved in the transaction.
Could you focus on what we're trying to decide? I appreciate that trying this case is going to be very complicated and expensive and onerous.
I understand.
But we're trying to decide a very narrow question.
Right, and I believe that, well, with respect to articulating precisely the standard, again, I've done the best I could in cobbling together the case law. In terms of Mann, I believe that it is good law. I welcome the opportunity, if you want, to try and craft something to take a look at it so that rather than I'm taking snippets, I provide you with a little bit more input in terms of what the court is looking at with respect to this issue. So maybe there's some balancing there. That's what the statute's about. On one hand, you have a balancing whereby the defendant triggers prong one, it shifts to the plaintiff, and they have to deal with prong two. I think we have to have something here so that this doesn't tilt to become where I started, a weapon of mass destruction, something that all you do is you file these things, and the action that has merit is stayed in its tracks for a long, long time.
Well, I think one of your real concerns is that any incidental or collateral factual or allegation not stop the process of the litigation.
Yes. There's no tool right now. That's why I'm trying to work within the confines of the legislature how to do it, because once you trigger the SLAPP statute, you've got that automatic stay in place, and that's what courts are adhering to. They're not allowing parties to just go ahead and get relief to move forward. You'll get limited relief, but it's very difficult. So there's a lot of practical aspects on this, and I would like to put more thought into what you're saying because I see what you're grappling with, and how do you set up that standard so that everyone down below, that we're not just slapping allegations and having this being used in a way that it never was intended to deal with meritless actions, and that it doesn't all of a sudden stop things on incidental.
Thank you, Mr. Sawyer.
Thank you.
Thank you, Your Honors. The Mann decision said if they're smushed together, if anything in the smush survives, it survives. We now hear an argument agreeing with us that if there's separate primary rights, there can be an A-SLAPP. We agree. That's the rule, that's the law. Cause of action is defined by primary rights. So the concern that's been raised by the questions, Your Honor, of course, is how do we define primary rights and how do we avoid incidental attacks on pleadings? Let's start with defining primary rights. This definition they gave is correct. The harm suffered has to be different. And if it's not seeking relief, then it could be incidental allegations. So let's apply that here. I think we've got the standard. Let's apply it here. Are there different harms? There are two buckets of claims that were smushed. One of the Livet claims, which is a completed transaction seeking damages from that completed transaction.
Before we get down to these facts, could you just articulate the rule for me?
Yes, Your Honor. An anti-SLAPP motion can be brought as to any primary right that's alleged in a complaint.
And the primary
as long as it
right,
arises out of protected activity.
Right. And the primary right is defined as?
Primary right, as this court is defined as, number one, there must be a duty owed to the plaintiff breached by a wrongful act of the defendant for which they seek relief. That's a primary right. If the harm is different than another primary right. Your Honor, primary rights, you have a car accident, California is very clear. The personal injury is a different primary right than the property damage. You may not have thought that, but that's clear-cut law, California law. The primary right for personal injuries is different than the property damage to the car. That's established law in California. And the fact is, Your Honor, in this case, applying that test, was the harm a different primary right? And the answer is yes. One bucket is the Livet claims over, I want damages from your keeping me out. The other bucket is the damage to reputation caused by the false Moss-Added audit. I'm not making it up. If you read the allegations, he says that the audit had inaccurate conclusions. They want a revised written report to address by injunction his injuries, which is to his reputation. It says there were erroneous facts in there. In paragraph 41, it says for the Livet claims, we want damages. But for the Moss-Adams claim, we don't want damages because they wanted to get around the slap ruling. We only want an injunction to cure the injury to our reputation. If Mr. Barral was not mentioned in the Moss-Adams audit, or Mr. Barral was only mentioned in positive things, we would not have an injunction. The predicate harm of the injunction, a relief, not collateral allegations, was injury to reputation. That's why it's a separate primary right, because and by the way, it occurred at different times. Look at the allegations of the complaint. The Moss-Adams audit was in December of 2010, and the Livet claim was at different times, both before and after. They were different events. Exactly what this court has said in multiple opinions.
So if a slap action, a slap motion is directed at one primary right, as you put it, the entire litigation stops?
And yes, Your Honor, but there's a reason for that. It's called the California legislature told us that. You know, there's a lot of people say the anti-SLAPP statute is a weapon of mass destruction. That's been presented to Your Honors multiple times in Briggs and Equilon, and each time you said it's up for the legislature to tell us whether we want these causes of action to be subject to anti-SLAPP. This court said the automatic stay in the variant decision applies. Yes, it has that effect, but that's as a result of the legislature. And you know, when I get bored and pour myself a glass of Chianti, I read a statute. The first...
You need help, Mr. Wagner.
I need a life.
Could I ask?
Of course. And Your Honor,
fascinated as I am to learn what happens with the Chianti.
I'm with you.
I want to go back to my very simple hypothetical where there's a bad statement at the public meeting and a bad statement at the card party. Both of those, if they were pled separately, they would be two separate causes of action, and they would both relate to injury to reputation, would they not?
Different injuries to reputation, Your Honor.
Okay, so different injuries because they happened on different days.
Different defamation. You and I get in a car accident today outside, and we get another car accident tomorrow. You hurt your back in both accidents. I'm at fault. Two causes of action. No question about it.
So you would say that even though there is the same primary right involved, injury to reputation in this case, the court should be able to strike one of those causes of action because one arises from protected activity and the other doesn't.
Yes, Your Honor.
And that the same rule should apply whether the pleading smushes those together.
Correct.
Alleging the same injury, the same.
Here we go. If you say category of injury, we're not on the same page.
No, I'm not going to say that.
Okay.
But the same primary right, my right not to have my reputation besmirched, it's the same primary right involved.
Your Honor, may I address that briefly?
Well,
it's not the same primary right if it's two different defamations.
It is two different defamations, but what makes them different is they arise from two different actions. Of course. Right?
Yeah, like the two car accidents.
I have a primary right not to be defamed.
Correct.
And I have that primary right every day.
You do.
So if it happens seriatim, I can claim seriatim claims.
Seriatim causes of action, yes, Your Honor.
All right. So there's a little overlap here between how we understand the term primary right and what we require in terms of the allegations regarding the damage to that primary right.
Yes, Your Honor. But Taus answers it.
Okay.
4 separate invasions of privacy, smushed together in a single cause of action, and this court struck 3 of them and kept 1. Because although it would all involve your right of sensibilities to be free from an invasion of privacy, they were 4 separate invasions of privacy. Contrast that with, I breach a contract and you have damages in specific performance, that's the Supreme Court's decision. So we come down to this is not incidental. They seek relief from it. They seek an injunction. When you seek relief from an allegation, it is not incidental as a matter of law. You look at Cho, look at Colton, look at Taus, look at these cases, and you'll see when you are seeking a remedy for that separate harm, it's never incidental. It can't be. Your Honor's question, I've forgotten which, sorry, would it be a separate cause of action? Of course it would. The reason it's not is because they lost the anti-SLAPP motion to begin with, and they were trying to avoid the allegation that they were going to face it again. Read those paragraphs, and you'll see if they were separately stated, it'd be a cause of action for injunctive relief based on the allegedly false nature of the Moss Adams audit. That's quite different than give me more money for the deal I've already approved. And with that in mind, Your Honor, with a glass of Chianti or not, it's the first paragraph of the statute. This statute is supposed to be broadly interpreted to achieve its purposes because the legislature determined there are too many lawsuits that are attacking speech and petition activity that's protected. It would defeat the statute if we allow someone to place into a, quote, single count protected activity that must stay in that case until we get to trial. That is not what the law contemplates. We've raised this issue throughout. We cited all the cases on primary rights. Your Honors have the right to address this issue, and this is the time, and we appreciate the opportunity to exchange with you. Thank you, Your Honors.
Thank you, Counsel. The matter is submitted. This is the matter of People v. Espinoza, Jr. Mr. Ortega, you may proceed.
Thank you, Your Honors. Good morning. May it please the Court. The trial court did not err in conducting this trial in appellant's absence. A voluntary and intentional absence of a self-represented defendant forfeits the trial rights otherwise afforded by his presence. And Penal Code Section 1043 authorizes the trial to continue without a knowing and advanced waiver of the trial rights.
Do you think that the defendant in this case was actually aware that the trial would continue in his absence?
I think an argument could be made that he was when the trial court tells him, you're not going to get any other lawyer. You're not going to get another lawyer even if you ask for one. So I think you can make an argument that he knows if he goes, the trial could continue.
Does it matter if there were evidence that were incontrovertible indicating the defendant did not know?
Okay, I don't think it matters because I don't think there has to be an advanced knowing waiver of your right to confrontation and your right to put on a defense. I acknowledge that he told the probation officer in an uncross-examined statement, I thought, based on what another lawyer told me, that there would be a mistrial. Be that as it may, well, first of all, there's reason to doubt that statement given all the lies he told the trial court.
Even if there weren't, is that dispositive?
It is not.
Subjectively thought might be a legal outcome of his conduct?
In our view, it's not. Parento is the dispositive rule here, and that states a defendant who has exercised his right of self-representation by absenting himself from the proceedings may not later claim error resulting from that exercise. Now, I acknowledge that the trial court could have taken another road here. When the trial court makes the finding it did, that Mr. Espinoza is doing this to manipulate the process, Mr. Espinoza is doing this to try to sow more delay, then under this court's precedence in Clark, Stansberry, Carson, it could have said, I'm going to revoke your self-representation rights. But the fact that he could have done that without error doesn't mean that he made error here
Do you have any insight into why it is that the trial court did not do that? Instead, the trial court seemed to put itself into a rather difficult position of having to try to anticipate what the defense positions would have been had somebody been there to represent the defendant.
I think what was going on was, that, as the trial court stated, this is the oldest case in the courthouse that's not a homicide. The victim has already testified. The jury's already been sworn. We're coming back from the second day of trial, and Mr. Espinoza has voluntarily absented himself.
Would it have been prudent for the trial court to appoint counsel?
The trial court, let me put it this way, Your Honor. If the trial court had appointed counsel, I'd be here defending that ruling from the argument the defendant would make that that was a violation of my Feretta rights.
And do you think that that argument would be successful?
I think both arguments fail. I think in this situation, as this court stated in Carson, these sorts of issues put the trial court to tough judgment calls in a combat position. And to get back to Your Honor's question, here the trial court had a jury, had one witness already testify, 5 witnesses lined up. If the trial court revokes self-representation and appoints an attorney, we might have a delay. We might have a continuance. We don't know that Mr. Campari, who he had just relieved as the defendant's counsel, would have been able to walk in right away and take over the trial with no delay.
And wouldn't we have had a whole nother problem with Mr. Campari if he were reappointed to the case? Hadn't he been the subject of multiple Marsden motions, and hadn't the defendant been insistent on removing the attorney, and even at one time indicating something about having an affair with the investigating officer?
I agree with you, Your Honor. I submit that had the trial court stated, I'm going to revoke self-representation, I'm going to appoint Mr. Campari, and the trial continued, that on appeal, we would have had an allegation that you violated my Feretta rights and you put back in the lawyer who I spent pages and pages and pages telling you was not doing a good job for me. Which is why I go back to this court's language in Carson, which is we need to give trial courts deference in these situations. The trial court here had a jury, had witnesses lined up. Some trial courts might have nevertheless said, you know what? I'm going to revoke self-representation. I'm going to appoint counsel. This trial court decided not to do that. And our position is that this trial court did not err when it continued with the trial. Now, let me go back to something Justice Kruger mentioned, because what she mentioned is the position that the defense takes in this court. And that is, not only should the trial court have revoked his self-representation rights, but the appellant argues that's in fact what the trial court did. And the defense relies on the trial court statements during the trial. I'm taking into consideration what I think the defense might have argued on this issue, and then at the new trial motion, the trial court stated figuratively, at times I sat in the chair of defense counsel. I don't think we can read from that language that what the trial court actually did here was act as the appellant's lawyer and therefore constructively revoked self-representation and should have appointed someone else, because we know the trial court can't act as the defense attorney. I think what the trial court was stating in the highest tradition of the judiciary was it was bending over backwards to be fair and achieve due process when the defendant had put them all in this position.
Did the trial court speak to whether the defendant would be aware that the trial would continue in his absence? Did the court make a finding on that?
He did not, Your Honor. There was no finding from the trial court that...
Is that a problem?
I don't think that it is. I don't think that the defendant has to give a knowing and voluntary waiver beforehand that says, if I decide not to show up, I know the trial can continue in my absence. And I have 2 reasons for that position.
Well, I'm not saying that the defendant had to give a waiver. I'm saying, did the trial court have to even address that issue and find by inference or whatever?
He did not, Your Honor, and this is why. Because at the new trial motion, The defense argued, Your Honors, we think you erred by not appointing counsel, but we acknowledge the Parento case as the controlling authority that was before you, so on appeal, we'll argue that Parento is wrongly decided. And Parento has no language in there whatsoever that suggests the appellant or the defendant has to knowingly waive his confrontation rights before a trial can take place in his absence.
But in Parento, wasn't there some indication that the defendant there knew that the trial was in fact going to proceed in his absence? He said, and sort of invited it through his communications with the court.
That was the reading of the Court of Appeal, and we disagree with that reading. We think that the defendant in Parento was essentially doing what the defendant here did, which is, in Parento, essentially baiting the trial court, daring the trial court. Go ahead, do it without me then, and just send me a letter when it's over, after his continuance motions had been denied. The Court of Appeal said that shows that there was a knowing and voluntary waiver of trial rights. He knew the trial was going to continue, and that's the rule. We don't think that's the rule. Cases aren't authority for propositions not considered therein, and nothing in Parento addresses whether or not the defendant has to know the trial is going to continue. Parento is simply a case where the court says, you leave, you've got no basis to claim later that there was error. It's forfeiture, and it makes sense. In this case, the defendant knew he had to be aware of the rules and the procedures. One of the rules and procedures that was pending, as his new trial motion attorney stated, was Parento was the rule.
And he was charged with that knowledge because he undertook to represent himself?
Exactly. You're charged with that knowledge when you're told, you make any mistakes along the way, you can't allege ineffective assistance of counsel later, which in our view is exactly what's happening here.
In other words, if you decide to waive your right to counsel and represent yourself, you will be held to know what any competent lawyer would know about the proper procedure.
Correct. And if you don't and you make a mistake, you shoot yourself in the foot, which often happens, you can't allege on appeal ineffective assistance of counsel.
Well, we know that.
Right.
But this is a somewhat broader question, which is whether or not the defendant, as Justice Kruger suggests, the defendant can be charged with knowledge that the trial could proceed in his absence because a lawyer would know that.
I agree. That's what I'm proffering. But I also think it doesn't matter. I don't think there has to be a knowing and voluntary waiver of your confrontation rights before the trial can continue in your absence. What the trial court is essentially doing is respecting your decision to represent yourself. We know in this case he made a voluntary and intelligent waiver of his right to counsel. He's never challenged that. In fact, in the new trial motion, his argument was, you erred, Judge, in not granting my two previous Ferretta motions.
Didn't he make the argument that there were 3 Ferrettas, and he made the argument that the court's denial of the first 2 Ferrettas was error and the grant of the third Ferretta was error?
No. His argument was the denial of the first 2 Ferretta motions was error, right, and no error in the grant of the third. The error was that you didn't revoke my self-representation when I...
What do you make of the Johnson claim of error by Mr. Espinoza, that either the court should have inquired whether I was competent to represent myself, or the court, I think the other part arguably is the court should have revoked my Ferretta rights?
I think what we need to do is look at the context of the record, and at one point, I think it's at page 413, the trial court tells Mr. Espinoza straight out, you're competent to stand trial. You're not mentally ill. Granted, there were many statements before that where the trial court was suggesting Mr. Espinoza had a problem processing information, that he might have had a personality disorder, but ultimately the trial court said, you're a liar. You're just lying to us. So this suggestion of Johnson that there should have been this inquiry and this denial of self-representation because of the inability to represent himself is forfeited because it wasn't raised below and is just belied by the record. I've made many of the points and all of the points that I was hoping to make. Unless the court has any questions, I'd submit.
Thank you, sir. Thank you, Mr. Ortega.
Good morning, Your Honors. Just checking. I feel like I've come full circle. The very first brief I filed in this court was Brosnahan versus Brown. And this may be my last. I'm hoping the first one didn't work out so well. Hoping to recoup.
But you're persistent.
I'm persistent. Thank you. Yes. Well, that's a defense lawyer for you. Your Honor, I want to first speak to the question of the Parento case, which the state has really focused on. And our position is that the Parento case is not good law anymore. When Parento was decided back in, I believe it was 1979, was relying on this court's decision in People versus Tyrone. And the idea of People versus Tyrone was it's okay when a defendant is granted the right of self-representation to let him put forth whatever defense he wants, including the defense of non-participation. Doesn't have to participate, can put the prosecution to its proof. The position of Parento, what Parento drew from that was that in any time a defendant decides to defend his case by non-participation, that must be, and here's a quote, respected. The trial court must respect it, and the Sixth Amendment actually prevents the court from revoking in that circumstance. Now, why do I say it's no longer good law? Because in the early 90s, this court in a number of capital cases, particularly People versus Clark, People versus Stansberry, came up against the following situation. A defendant is in the trial court, and the defendant gets exasperated, and he says, I'm going to stand mute. I'm not going to participate in this sort of business. And the trial courts in both Clark and in Stansberry said, oh, no, you're not. I'm going to revoke your right of self-representation, because I don't think that's you're putting forth a sincere, legitimate defense. You're actually trying to obstruct the process of the court.
Is there a distinction to be drawn between a defendant who simply chooses to sit in the courtroom and stand mute and somebody who just doesn't show up?
I'm sorry, doesn't
show up?
And doesn't show up? Actually, no. There is no, let me back up. The Sixth Amendment requires the court to determine whether the decision to stand mute is and this court requires it through Clark and Stansberry, whether that decision is a sincere effort to defend the case or whether it's an effort to obstruct the court and so err into the record.
I understand that. I'm asking whether there is a distinction. You are characterizing this as a decision to stand mute, and I'm questioning that characterization. It seems to me it's not just a decision to stand mute, it's a decision not to show up.
Absolutely. And so the answer to your question is that it depends. If not showing up can possibly be construed as similar to a sincere effort to put on a defense, well, then the answer is yes, but it can't be. It can never be. When a defendant absconds, an out-of-custody pro se defendant absconds, it is always going to be an effort to obstruct the trial or so err into the record.
So that would provide he's not run over by a bus or
he's not in the hospital. So let's say an unjustifiable absence, it is always going to be for obstruction, just as the trial court found in this case.
So I think we can agree with you that that would provide a sufficient basis to revoke the right of self-representation the day that the defendant doesn't show up in order to obstruct the proceedings. But the question before us is whether the trial court has to revoke that right.
Exactly. And my position is that for two reasons, the trial court was obligated to revoke. First, let me talk about the reason based on state law. This court decided in People versus Carson that because the trial court has discretion to revoke, the trial court must consider 3 factors. Was the defendant warned? Is there a sanction that can bring the defendant back? And is the defendant's conduct deliberately obstructive? This court said that the 3rd factor, if the trial court finds is deliberately obstructive, that in and of itself is sufficient to revoke. Now, the trial court in this case, when the defendant failed to appear, had the discretion, and in considering those 3 factors, each one of those factors militated in favor clearly of revocation.
So we've heard from your friend on the other side that one of the reasons that factored into the trial court's decision in this case was a concern about further disrupting the proceedings, about, the jury was already ready to go.
Right.
This would have sort of played into the defendant's strategy of trying to delay the case at any expense.
Right. Mr. Campari was excused, I don't think a full day before this happened. It was in the afternoon of the previous day. He didn't show up the next morning. Mr. Campari was a public defender, was on the case for many weeks, many months. He was prepared to go to trial. He had just left the courtroom. He was completely available to come back.
But your client moved heaven and earth to get rid of Mr. Campari. And so there are competing concerns here. It is true that your client has a right to be represented by counsel. Clearly, that's the case here in America. But one of the supporting notions in Ferretta is there is an equal right not to be compelled to have a lawyer who is, in your judgment, not able, willing, competent to represent you. And if that's your point of view, you get to say, not him. I'll represent myself first.
Not a single one of those Marsden motions was granted.
Right, because Marsden is different from Ferretta. And we know, because we see it constantly, when you lose a Marsden, the next thing that happens is Ferretta. It doesn't always happen, and it's not wise to have it happen that way from the standpoint of the defendant most of the time, but that is often the line of march.
But if Your Honor is asking, could the trial court have appointed Mr. Campari, reappointed, ordered him to come back and get back into the trial, there was no legal obstacle to that. He had not.
What about your friend's argument that had that happened, you'd be arguing that his Ferretta right was trampled upon and he was compelled to go to trial with this lawyer he despised?
And just like Brosnahan versus Brown, I would have lost. I would lose that. Because there was no basis for granting any of the Ferretta motions, the repeated Ferretta motions, Marsden motions, as the trial court found. The defendant at this point has failed to show every factor in Carson militates in favor of revocation, and the court is in a difficult position because there's a jury there.
Can I ask you to go back to, you said you had 2 reasons why the court was obligated to revoke. And so we're talking about court's discretion. This is a highly unusual circumstance. This is really an unusual circumstance. This is an insistent, I don't think you can find a more abusive record of how many Marsdens, how many Ferrettas, how many PDs, how many DAs, 2 years, 9 months. I'm not going to go into that. I know you know it.
Can't disagree.
So I want to know, what are your strongest arguments that said the court no longer had discretion? The court, when the defendant who completed jury selection, declined an opening statement, the victim is the first witness, the DA conducts direct, Mr. Espinoza declines cross, and the next day he's in the wind.
Right.
So why is the trial court, after saying, I have this jury, I have these witnesses, this is the longest case in the courthouse, we're going to go, you don't get anything but reasonable continuances, you don't get special treatment, we're going forward. Court does all that.
Right.
Now you're telling me the court has no discretion. It's obligated to revoke under those circumstances, and I'd like to know why besides Carson.
Well, let me, if I might just finish my point with Carson, which is that because all 3 of those factors militated in favor of revocation, it would have been an abuse of discretion for the trial court to find otherwise. The trial court did not exercise its discretion under Carson. The only thing the trial court did was refer to Penal Code Section 1043, which allows trial in the absence of an absconding defendant, but says nothing about the right to counsel. The trial court did not consider Carson or any of the factors, but since they all add up and point in the same direction, it would have been an abuse of discretion for the court had it applied Carson, as it should have. It would have been an abuse of discretion and for the court to make a contrary finding. That's number one. The second reason I was adverting to, Chief Justice, is under the Sixth Amendment. The right to self-representation is not absolute. We know that in the trial court there are public interest values that can confine and limit the right to self-representation. It has to be timely made. It can't be obstreperous. There can't be obstruction, those sorts of things. Similarly, there's no right to counsel, the United States Supreme Court tells us, no right to self-representation on appeal. Why? Because there are public interests involved in the appeal in reliability, in fairness, and the appearance of fairness. And those are the state's interests that have to be safeguarded in a proceeding. Now, at the trial level, when this whole thing started and my client was bringing his Feretta motions, his autonomy right to present his case to the jury outweighed the public interest right. It was higher. Now, when he's fled, he doesn't have this autonomy right anymore. It's gone. There's no autonomy in presenting a case to a jury. He's, as Your Honor put it, he's in the wind. The state's interest in fairness, reliability, and the appearance of fairness remains very strong. And here you have a public criminal trial with a judge who I contend is acting like the defense counsel, a prosecutor, and an empty table. It's like some sort of a grand jury proceeding. It does not meet the requirements of Wheat versus United States of fairness, reliability, and appearance of fairness. Because it's not
talking about balancing interests.
Pardon me?
Since we're talking about
Yes.
balancing interests, suppose your client didn't abscond on the first day. Suppose he absconded on the fifth day. Mr. Kaspari, or whatever his name is now in trial in a different case.
Okay.
So he's not available. Now what's the court supposed to do? Appoint a different lawyer and wait for some amount of time while that lawyer gets up to speed?
Yes. And here's the reason.
So everybody just gets to sit around while that happens.
No, here's the reason, Your Honor. When the trial court took the Feretta waivers in this case, the trial court, told the defendant, among other things, told him, if you misbehave, the court may revoke your right to self-representation. If a new lawyer has to come on to the case, that lawyer will be at a severe disadvantage. So the defendant, entered a waiver to that effect. So the defendant has effectively waived the problems that you're raising. He can't complain if a new lawyer comes in and is given 30 minutes to prepare.
So that's it? So the trial court should say, go out into the highways and byways, find me a lawyer, and when this poor soul shows up, the trial court says, you have over the lunch hour to prepare.
Absolutely. And
the court could compel a member of the bar to represent a person charged with a felony under those circumstances?
That's an interesting question. In People v. McKenzie, this court said yes. People v. McKenzie was exactly that situation. It was a obstreperous defendant, appointed the public defender. The public defender said, I ain't doing this. I can't do this competently. I have, the rules of professional conduct. And this court said, it's your obligation. And it can even be enforced.
For McKenzie?
I'm sorry?
Do you have the site for McKenzie?
Would you like me to search for it?
Don't take your time to do
it. I'm thinking it's 34 Cal 3rd, but I can give you the exact.
I can find it.
It's, McKenzi. And the court said that this court said the trial court has the power of contempt to force an attorney to take the appointment. The public defender has to take the appointment. And in fact, it said it was
defend that today?
Would I?
Mm-hmm.
Absolutely.
You would?
I would.
Okay.
Consider the choices, Your Honor. There's an empty table with no defense lawyer, or there's a public defender who's used to working on his feet, comes in and handles the case. Which would you choose? I mean,
the third alternative is to proceed in the absence of the defendant.
Without a lawyer.
He's his own lawyer.
Oh, he's gone.
That's his choice.
I'm sorry?
By choice.
Well, but, Your Honor, that's true in every case where a defendant in court is obstreperous, interferes, and gets expelled. That's his choice. The court warns him. You do it one more time, you're out of here.
Right, and the very next day, the court says, calls him back into court and says, are you willing to behave today, Mr. So-and-so? And they get an answer. He says yes. He says no. He says yes, we proceed. Does it every day because the body is there. Because you're generally talking, in most situations, when they're obstreperous and they get booted, they're in custody. This fellow is out of custody.
He's out of custody, and that's the problem. But the problem I
don't think that he's being out of custody is a problem, but I think it adds to a layer of whether you're on one side or the other, opportunity or manipulation for how a trial court should proceed. In this situation, it's just factually hard to determine what the court's supposed to do. The trial court was really stuck with an unprecedented and really feeling its way and used 1043b2 as an opportunity to proceed, laying out what it did in the record, and going to the extraordinary step of saying, I'm going to bend over backwards, as you say, and I'm going to consider the arguments that could have been made by Mr. Espinoza if he were present. Given, however, the fact that when Mr. Espinoza was present, he was not particularly active as an attorney. So in this case, I'm still not seeing, I'm seeing why you might characterize what the court did as having choices and that it was an abuse of discretion. Besides the Carson factors and your argument about the Sixth Amendment, do you have any other basis for saying here the court's discretion was extinguished, it was required under these circumstances
well,
to revoke?
My third argument is, now if we're assuming the court did not revoke,
purposes of your
for
answer,
purposes of this question, I'm assuming the court has not yet revoked.
Correct.
My third response is that the trial court, based on its own admission, sitting in the chair of defense counsel, actively working on the case as defense counsel, effectively, constructively revoked the defendant's right of self-representation. The way we get to that argument is that the state has said repeatedly that a defendant who decides not to participate has control of his case. It must be respected. Well, the trial judge did not respect that. The trial judge in this case conducted sua sponte one 402 hearing, just on his own, decide we have a 402 hearing. More interestingly, he conducted a second 402 hearing based, according to him, on the ground that the defense lawyer, Mr. Comperi, had initially discussed having a 402 hearing in this case. Now, if the defendant is supposed to be in control of his own defense, how is it that the court can call a 402 hearing based on something that his discharged lawyer wanted, that he didn't want his discharged lawyer? If the defendant's in charge of his case.
Are you asserting that somehow your client was suffered some egregious harm because the court bent over backwards to make sure that there was a hearing before evidence was admitted?
Your Honor, this falls under one of those civil code aphorisms of no good deed goes unpunished.
Well, I would agree with you there. I mean, I'm trying to find out what the harm is. Ordinarily, we hear arguments that the trial court was acting like another district attorney. Right. What an outrage. Right. And now we're hearing that the trial court is acting in an attempt to protect the rights of the defendant, and somehow we're outraged.
Your Honor, the harm is to the defendant's right of self-representation. And it's the same sort of harm that occurs when an advisory council gets overly involved in the case. In McCaskill versus Wiggins, the U.S. Supreme Court has said there are limits to what an advisory council can do, because otherwise it frustrates and eviscerates the defendant's right of self-representation if he gets too overly involved. It effectively, eviscerates that right. And that's exactly what happened with the trial court here. What McCaskill says an advisory counsel cannot do is make tactical decisions. He cannot speak for the defendant. He cannot, I read you the language, he cannot speak for the defendant, and he cannot call witnesses, for example.
That presupposes that the defendant is there to assert his own wishes in that regard.
With respect to the advisory counsel, sure. But
Because
the advisory counsel...
the defendant has taken over his own defense.
I'm sorry?
Because the defendant has taken over his own defense and is there to assert it.
Right. And if the advisory counsel goes too far, the harm to the defendant is that he's lost control of his defense. Now, Mr. Ortega has taken the position that the defendant, in this case, had the right to control his defense however he wanted. That wasn't the trial judge's position. I'm not going to let this guy control the defense. I'm going to have 2 402 hearings.
I think you can also argue that what the judge did was control the DA, not so much control the defense case, but control the DA in terms of 402 and making sure that whatever evidence in terms of provided by experts, that the prosecutor, absent a defense attorney, is making sure that this is a fair and balanced trial. But I want to say, Mr. Gibbs, your time's expired, but you may make your concluding remarks.
Thank you, Your Honor. May I just respond very briefly to what you just...
Yes.
It's impossible to square what you just said with what the trial court said. And he said, I, as a court, voiced a defense position on behalf of the defendant as if he were here during trial. I iterated what the defense would want on all substantial issues and motions. He sat in the defense counsel's seat, and the harm was to the defendant's right of self-representation. So, Your Honor, our position is that the trial court should have revoked, and once the court had revoked, it was imperative to have appointed counsel under the Sixth Amendment and under California law. We'd ask to affirm the Court of Appeal. Thank you.
Mr. Gibbs.
Very briefly, Your Honors, Mr. Gibbs's last remarks were the trial court should have revoked, but his argument earlier was that the trial court had no discretion to revoke, that the Constitution required him to revoke once the trial court found that Mr. Espinoza absconded for manipulative reasons. And there's no case anywhere that holds that. The trial court had the discretion. As this court stated in Carson, these cases present trial courts with very tough judgment calls. We're going to give deference. And the trial court deserves that deference here, given all of the circumstances that many of Your Honors pointed out. And one last statement. I wouldn't want to be the DAG up here arguing that there was no ineffective assistance of counsel from the public defender who was dragged out of the lunchroom into this trial courtroom on the 5th day after Mr. Espinoza absconds. It's just not constitutionally compelled that the trial court at that point has to revoke self-representation and appoint another counsel. The trial court could factor in, I could be risking reversible per se if I revoke. I'm going to be risking IAC claims if I call in a lawyer and give him 5 minutes to prepare. I'm going to be risking reversal per se if I bring back Mr. Campari, who this defendant essentially detested. Unless the court has any further questions, we submit.
Thank you, Mr. Ortega. The matter stands submitted. We are in recess until 1:30.
Please be seated.
Good afternoon. Welcome to oral argument. We'll have the clerk call the calendar.
Good afternoon. Supreme Court of California, sitting in San Francisco on Thursday afternoon, May 7th, 2016 at 1:30 p.m. Case number S139103, the people, plaintiff, and respondent versus Bailey Jackson, defendant and appellant. For appellant, Richard I. Cargo.
Ready.
For respondent, Tammy Hennick. Thank you, counsel.
Thank you, Mr. Targow. You may proceed.
Thank you, Your Honor. May it please the court, I know this is the end of a long oral argument week for you, so I will try to keep it as brief as possible. Just to frame the argument, it seems to me there were two major errors in this case. The failure to sever the Myers counts and try them separately, and the admission of the canine identification without either a Kelly or a 402 hearing. And I think either warrants relief in this case. And the reason why either of them warrant relief in this case is that even with the joinder, even with the graphic details of the Mason attack, and even with the Maggie May pointing her nose at the appellant, even with that, there were jurors who harbored lingering doubt. So I believe that that really is the best indicator of the prejudice involved here. Now, turning to severance. You know, in Soper, this court said that even if a trial court is correct, and I'm not conceding that, but even if a trial court is correct in denying the severance, the reviewing court must determine whether in the end the failure to sever resulted in gross unfairness, depriving the defendant of due process. So even in Soper, there was an acknowledgement of the tension between our statutory preference for joinder and the due process clause. And in fact, there is that word regarding admissibility that the court used when it said normally cross-admissibility is sufficient to allow joinder. I think this is not a normal case. So it's not the normal case for two reasons. One, on this record, this court cannot determine whether the jury convicted appellant of the Myers crimes on the basis of the evidence related to Ms. Myers or on the basis of what they heard about what happened to Ms. Mason. And second, even though they did hear all of this inflammatory evidence regarding Ms. Mason, and even though, as I said just a minute ago, the dog implicated him, there was still some lingering doubt. So we have a tension here between the statutory preference and the need to avoid gross unfairness. And I'm going to suggest to the court that perhaps for the guidance of lower courts, there needs to be a corollary to the rule set forth in Soper. Now, in Soper, you said with respect to when there's no admissibility, you gave a three-part formulation, whether some of the charges are particularly likely to inflame the jury against the defendant, whether a weak case is joined with a strong case, and whether one of the cases but not another is a capital offense. Well, I think there's a logical corollary to that formulation which will help guide the courts avoid this kind of a case. And here's how I would propose that it read, that even where there is some cross-admissibility, when one, a weak capital case is joined with a strong non-capital case, and two, when the strong non-capital case contains charges or evidence that is particularly likely to inflame the jury against the defendant,
Counsel, and how do you define a weak capital case here?
I would say where the evidence is weak. I think that this case here is the quintessential example of a weak capital case. I can't give you
more of a general rule. Like it's one thing to sort of respond to the evidence, and certainly one could make that conclusion. But as a more general matter, there isn't anything more to articulate.
Not that I've thought about, Your Honor. So let me just get to the third part of this. So we have a weak capital case. The strong case has inflammatory evidence, and the inflammatory material is not related to the cross-admissible material. Then in cases such as that, I suggest that the statutory preference for joinder should be replaced by a presumption against joinder.
So you would just have us create a new presumption against joinder?
In this limited classification of cases, yes.
Well, but whether it's limited or broad, you're asking us to create it.
I am, because I think that's the only way you can guide the lower courts to harmonize this, what I think is a tension between the statutory preference and the due process clause when it comes into play in a case such as this, when there's such incredibly inflammatory evidence in a very strong non-capital case that's joined with a weak capital case. And I just think that it would provide guidance to the lower court so that we don't end up with the reviewing court after all of the trial having to say, gee, there was gross unfairness here.
Well, isn't with the exception of the presumption, isn't all of that part of the 352 analysis?
Well, I don't think that it's sufficient, Your Honor, simply because we have this statutory preference for joinder, and I think that's what guided.
To create a statutory preference.
Pardon me?
The legislature gets to create a statutory preference.
Oh, absolutely they do.
So we are dependent on trial courts to mediate the harshness of that preference in appropriate cases.
Yes, but I think the natural tendency is going to be always in favor of that. What I'm saying is that there are some cases. What I'm suggesting really is something to alert the trial courts that there is a way for them to go against the statutory preference. That there is a means to say, this really falls into this particular small classification.
But how do we do that if you can't answer Justice Cuellar's question about how we would define a weak capital case? Because, I mean, you're talking about creating a presumption in a circumstance that's very case-specific that we can't quite articulate.
Right, but even the SOPR formulation says weak without defining weak. I mean, it has to be, it really ends up having to be, I know it when I see it. It has to be evidence specific. I don't see how one can define it any better than that.
Counsel, what is the gross unfairness here?
I think the gross unfairness is simply that all of that horrid evidence presented 3 times to the jury about what happened in the Mason case was presented to the jury in the joined cases, and I don't see how a juror could separate the cases, especially, by the way, in the absence of Calgic 1250. I don't see, but even with 1250, this had to have infected the jury and infected their minds. This is just such a terrible person, isn't? I mean, it even led to the prosecutor being able to stay silent during the whole case, and then at the end say, "Oh, by the way, nudge, nudge, wink, wink. He probably sexually assaulted her too."
Well, that was the prosecutor's theory of the case, was it not?
No, I don't think it was, Your Honor. Until the very end, the prosecutor, there was no theory of the case regarding Ms. Myers up until the very end. There was no evidence that he presented that clearly was going to sexual assault on Ms. Myers. There was nothing in the information which suggested, and this gets us into the supplemental briefing.
There was no sex crimes charged in the Myers case. That's true. But there was evidence developed. I mean, there was the evidence that the house was not ransacked, right? There was evidence that the dress was found on the floor.
Well, let me speak to that, if I may. Did you have more? I'm sorry, Your Honor.
No, I think those are the main things. Actually, there was also testimony from, I believe it was a granddaughter who said that Myers was a very tidy person, and so it would be unlikely that she would have left an article of clothing like that on the floor.
Yeah, but in addition, Robin Myers testified that her grandmother's dress and pantyhose, when she testified that her grandmother's dress and pantyhose were on the floor, also described a disarray in the bedroom. And, just things just kind of thrown on the bed rather than, I'm sorry, that's somewhere else. I believe that Deanna Myers also spoke to this. The trash can had been turned over. There was a door on the bedstand which had been pulled off and was leaning against the bedstand. And as a matter of fact, had there been anything approaching notice that he was pursuing this, and this is where I get to what Robin Myers said in the preliminary. In the preliminary, and this is at 2CT 221, she said there were clothes just kind of thrown on the bed rather than folded as she always did. She said the bedroom was in disarray with things scattered about. Now, if the trial attorney had any inkling that this dress and pantyhose were going to suggest that there was a sexual assault, then he would have brought that preliminary hearing testimony into the trial to say, well, really what it's consistent with was he was strewing clothes about. So, and then, excuse me, I've lost track. What was the second point?
Well, the fact that the house wasn't ransacked.
Well, yes, okay. Well, so the bed was. The bedroom was. The bedroom was, in fact, ransacked. And, let's look at what likely happened here. I mean, the respondent wants to say that he made a confession to the police. Of course, we argue that that wasn't admissible and also that it wasn't a confession. But if you credit that, then he stabbed her in the hallway when he first came across her, hardly showing any ability to engage in a sexual assault. So I just don't see how a competent, even a reasonably competent attorney would look at these charges and look at the evidence and say, gee, I better defend against a sexual assault having happened to Ms. Myers. Now, with regard to the, sorry.
I'm just listening very actively.
Thank you. Now, I just want to mention a couple of things with regard to the supplemental briefing that the court asked for last summer. And that's this. Evidence Code Section 1108, by its wording, precludes its application here because, and we're coming back to this, it's limited to application cases in which a defendant is accused of a sexual offense. And again, I contend that he was not accused of a sexual offense. And in fact, the very first words in story are when a defendant is accused of a sexual offense. And every case that I've been able to find applying 1108, there were underlying charges of a sexual offense, and there was an 1108B hearing to discuss this. And so that provided the notice that's absolutely missing here. So, turning to dog scent evidence, it's just incomprehensible here that the trial court had neither a Kelly nor a 402 hearing. I think perhaps, we could go around and around on Kelly, and perhaps Kelly doesn't apply here. I contend it does. But not to have a 402 hearing, all of the cases preceding this, Malgren and Gonzalez, all of them had at least a 402 hearing where they could look at the validity of this dog trailing.
The 402 hearing, the decision to make have a 402 hearing is almost always going to fall within the sound discretion of the trial court.
Well, yes, it does, except that I'm...
Nothing mandatory about having a 402 hearing.
No, I understand that, but when you have a defendant filing a Kelly motion, which is accompanied with a long article elucidating all the dangers of these kinds of identifications.
Is that one step removed from I read it on the internet?
Pardon me?
Is that one step removed from I read it on the internet? I mean, you can find an article to support virtually any position.
Well, except if you look at the article, it's supported by very substantial research. This was the Taslitz article in the Hastings Law Journal. This wasn't just off the internet. This was accompanying the motion, and so if the court takes a look at, he took a look at Malgren. He said, I'm satisfied under the Malgren formulation. All right. Well, the last thing in the Malgren formulation is that the trail has to not be contaminated. Well, except that in this case, unlike all of the other cases, this was not a fresh trail. I'm sorry, the trail was fresh, but the scent was not fresh. And so let's look at the string of speculations here that had to go into not having at least a 402 hearing. Right? First, that the perpetrator actually handled the crumpled envelope. Second, that his scent was still present on the ninhydrin-soaked envelope after 40 days. And had there been a 402 hearing, they might have presented the research that you see in Appendix B, that the success of experienced dogs decreased by 42% to 60% after only 2 weeks. Right? And also, they had to guess the dog was following the scent from the scent item, as opposed to, for instance, this dog was already familiar with appellant because he had already sniffed him. She had already sniffed him 3 days before, and we know from even that article, the Taslitz article, and other research that familiarity. I believe that even Dr. Harvey said this, that dogs can be affected by familiarity. Also, it might have been because the strongest scent. His was the strongest scent. Most important, there is one means of calibration, of something like calibration of a machine in a dog scent situation, and that's what they call a negative trail. A negative trail is where you present the dog with an unscented item to make sure the dog will not trail. And a negative trail was emphasized by Dr. Harvey as something she always did in her research. But Kobe Webb didn't do that in this trail. So we don't know if the dog was trailing because he was familiar with the scent or because it was the strongest scent around. We don't know if she alerted on appellant simply because he was the last one in the line or the only one sitting or the only one in an orange jumpsuit. And the problem here is we can't cross-examine the dog. So we have a sentient being making decisions, and by the way, sentient being who has a bias toward coming to a result because in their training they get rewarded, being handled by a handler who also has a bias to a successful alert, because that's how she maintains her job. And in this case, the handler knew who the suspect was. And we have that UC Davis research, which showed an extraordinary number of false positives, which were best explained by handler cueing. So in this setting, not to have a 402 hearing, and the judge, if he'd had the 402 hearing, would have at least heard this and been able to make a decision based on the evidence rather than his speculation that it was okay based on what he heard in the preliminary hearing. And by the way, in the preliminary hearing, there was no expert on the side of the defense. Finally, regarding the instruction, I just want to suggest again to the court that this instruction, which is now CalCrim 374, I would urge a modification of that. And what I would suggest is that when the canine evidence is the principal or a principal source of the identification of the defendant, that the jury really be instructed that the evidence be viewed with caution and that the corroboration be independent. My authority for that is what happened in this case, Your Honor. I'm suggesting that the court modify, again, this instruction.
You're suggesting that the court essentially comment on some of the evidence.
Yes. Well, let me.
Tend to not like that.
I'm sorry.
We tend to not like that.
Well, let me back up for a moment. All of these cases out of which this instruction grew were pretty much standard tracking and trailing cases. Okay, where there's a fresh scent, and where and it leads directly to the defendant and there's other corroborating evidence that he was there. But right now it allows corroboration that's not independent. And I think that when you have a case such as this, where the principal accuser, in terms of his identification, was the dog, that that's not sufficient. I think that I'm just proposing this to the court. The court will do what it wishes.
So are you making an insufficiency of the evidence argument here?
Well, I think runs throughout my brief.
Okay.
But I'm just concerned that this instruction, as it stands, is not sufficient for this kind of a case. Thank you.
Thank you, Mr. Targo.
May it please the court, Tammy Hennick, on behalf of respondent. The trial court properly denied appellant's motion for separate trials because the Mason evidence would have been cross-admissible in hypothetical trials, as the trial court properly ruled.
Is there any evidence that would have put the defense attorney on notice that the Myers case would be tried with a sexual component to it?
Well, the information alleged that appellant entered Myers' home with the intent to commit a burglary and a felony, and under Story, that's sufficient to put appellant on notice that he's being charged with an open charge of murder, including rape, felony murder. So, in addition to that, in the preliminary hearing, the evidence was offered that that crimes occurred of a sexual nature here, including the fact that Miss Myers' pantyhose and dress were discarded, and that the house had not been ransacked, and that plenty of property was left, including her purse and wallet on the kitchen table. So the evidence would have been, the trial court properly ruled that the evidence was cross-admissible, or would have been cross-admissible under Section 1101, but also the trial court could have ruled that it was properly cross-admissible under 1108 as well. The factors that appellant raises in suggesting a new test for SOPR are already taken into account here. When there is no cross-admissibility, the court already looks at the spillover effect and the joinder of a weak case and a strong case. And of course, we would disagree with the characterization of the Myers case as being a weak case. And not only did appellant move into the neighborhood just 10 days before Ms. Myers disappeared, but appellant's footprint was found on her kitchen floor. Appellant disappeared. He had a period of absence the night that Ms. Myers disappeared, around the time that Ms. Myers would have stepped outside to feed her cat. He came home, was sweating, and looked pumped up, and then disappeared again. It all correlates to the manner and the time in which Ms. Myers would have disappeared. Appellant confessed to killing Ms. Myers when he was being interrogated for killing Ms. Mason. And Ms. Myers' car was found in Las Vegas. An appellant and his girlfriend had told their friend, Joe, that they had been in Las Vegas around the time that Ms. Myers disappeared. So taking all of that into account, we would vehemently disagree that the case with regard to Ms. Myers' murder was weak. Moving on to the dog scent evidence. As we set forth in our brief, this is a traditional dog trailing case. These types of cases have been admitted in California for decades. No Kelly hearing was required, and no 402 hearing was required. As you pointed out, that it's well within the trial court's discretion to hold a 402 hearing. The court instead weighed the Malgren factors and argued that, or decided that the dog trailing evidence was admissible. The appellant argued throughout his brief and here that Maggie was probably following appellant because she was familiar with his scent. But in reading the record, a defense counsel told the court that he believed that both of the prosecution's experts and his own experts would testify to that, but that it turned out that none of them would. So he specifically said that on the record to the court, that he could not get any of the three experts to testify that one of the reasons Maggie followed appellant through the police station was because she recognized his scent from a prior trailing. All of the questions and all of the concerns that appellant has now about the dog scent evidence were addressed by the experts and the cross-examination of all three experts at trial. And it's a question of weight to be given to the evidence, and that was a question for the jury. If the court has no questions for us, I would submit.
Thank you, Ms. Hennick.
I'm trying to make sense of my notes. Excuse me, Your Honor. With regard to the cross-admissible evidence, with regard to the information, I just don't think Story can be read as the state would have it be read. As I said before, every other case actually had explicit, either in the evidence or in the charging document, even in Story, the previous charging document charged the rape. And so I don't see how just simply saying any felony without any explicit evidence of a sexual assault being brought out by the prosecutor, how that can provide notice to the defendant. And You know, this whole business about he didn't ransack, well, partially I've answered there. But I don't see how what he didn't do provides evidence of what he did do. This is kind of an absence of evidence, and how does a defendant defend against that? You can't put on a witness that says, well, because he didn't do that, what do you think, what does that mean? How does the absence of evidence, how does the absence of ransacking, and I will concede that there wasn't ransacking. To say, he had an envelope which the evidence showed had thousands of dollars in it, and he ransacked the bedroom for jewelry. And somehow this means, because he didn't ransack the rest of the house, that he engaged in a sexual crime. I don't see how logically that follows. Also, I just would challenge, the evidence was not that he moved in 10 days before. The evidence was that he moved in late March. There may have been one witness that said 10 days before, but the better evidence was, in fact, that he moved in late March. And this was, of course, on Mother's Day in early May, so this was not 10 days. This is not a typical dog trailing case. It's not a typical dog trailing case because A, the scent was not fresh, and B, because at the end, the dog made a choice between three, and the fact...
Was all that information brought before the jury?
Yes, but Your Honor, the whole point of Kelly is to say when you have an instrument, an instrumentality which has an aura of certainty, that it has to be validated as scientifically valid before you present it to the jury.
But didn't even the prosecution's witnesses admit that dogs make mistakes?
Yes, exactly.
So what about the aura of infallibility?
Well, because the aura...
Before the jury.
Well, Your Honor, they were so intrigued by this dog that they even... by the dog evidence in general, that they even started engaging against the rules of the court with Dr. Harvey in a break in the thing. And there was a picture that was left, he had pictures of the dog trailing that were left right there by the witness stand the whole time. So, and all of Dr. Harvey's testimony was, gee, bloodhounds are infallible.
Did a single soul say in this trial that hounds are infallible? Did anybody even remotely argue that?
I think the gravamen of Dr. Harvey's testimony was exactly that, Your Honor. She presented all of her, she talked about her research. She said bloodhounds are particularly good at this. And we have the entire history in fiction and in, we have this myth of infallibility of dogs, of the dog scent. And, I don't have any problem with dogs being used to track drugs or to identify cadavers. I don't have any problem with a dog that establishes probable cause. But here, this is identity. And there were so many places where this could have gone wrong. And if he'd had the 402 hearing and heard from Dr. Myers and read some of had presented to him some of the research beforehand, he might well have said, gee, this is actually not, this is really irrelevant because we can't validate the science here. That's all I have. I'll submit, Your Honor. Thank you.
Thank you, Mr. Targum. Ms. Hennick, the matter is submitted.